You're telling me he strikes someone in a car and then on top of it starts assaulting this person? How do we know he doesn't go home and chug a fifth of vodka? Mr. Carruthers, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 2nd, 2024, officers were dispatched regarding a major crash in Harris County, Texas. Upon arrival, the officers made contact with the wheel witness. The witness observed the defendant's 2005 gold Chevy strike an unknown person riding a bike with his vehicle.
Whoa.
Yes, Your Honor.
Struck a person?
Riding a bike. Yes, Your Honor.
Okay.
The defendant then got out of his vehicle and began assaulting the unknown person and then drove away from the scene.
Whoa. You're telling me he strikes someone in a car and then on top of it starts assaulting this person?
Yes, Your Honor. The unknown person fled the scene and the defendant was promptly found by officers 1 block away in a private driveway. That was not the defendant's residence. Upon contact with the defendant, the officer observed an odor of an alcoholic beverage, slurred speech, and poor balance. The defendant was detained. He refused SFSTs. The DIC was read. The defendant refused to provide a specimen. A blood search warrant was signed and executed. He was identified by his Texas driver's license.
I had just so many problems with this.
So, Judge, we have been unable to locate the unknown person that was on the bicycle. He fled because he was getting assaulted. We have no way of finding him.
Not only that, how do I know he's not consuming anything after the fact? How do we know he doesn't go home and chug a fifth of vodka?
I mean, the DIMS does say he was promptly found by the officers 1 block away.
I get it. I get it. Promptly, it's a conclusory word.
I'm pulling up the OR right now, Judge, to see if they have anything more specific.
Can I say something wrong? Don't, Mr. Carruthers. Don't. Are you losing?
No.
Then stop. Anything else? Was that it?
Looking at times, Your Honor, to see if we can establish when he was found based on when he was dispatched. I don't think we have anything additional, Your Honor.
It says, yeah.
Mr. Carruthers, I'm going to find no probable cause on your case. You know, we have enough death. We have enough dismemberment. We have enough blood all over our streets. Please don't add to it. Please just don't kill someone. That's all I'm asking you to do, man. You know, $40, an Uber will take you anywhere you want to go in this county. Anywhere. Please don't kill someone. Take a seat, please. Hi.
Well, I have 2 clients I need to post for. The first one is Gallegos. So he did do his drug test, but it's today.
For
The THC, but I wanted to see if we can allow the actual results coming back from the labs, because my client was quite surprised about
okay, so we'll put off 3 days, 4 days.
5 days.
And yeah, it takes about 5 to 7 days depending
Okay,
on how.
we'll set it off a week. It's okay.
And then my other client, Your Honor, is Mr. Randall.
What's the last name?
Randall.
What's up?
Fernandez.
Okay.
We want to address the bond. That's set at 10,000 right now.
Page 32, Judge.
Yeah, thanks.
Judge, do you want to box?
Yeah, because I don't know anything about it. Yeah.
Yeah, no, Fernandez.
And hold on, Owen, let me just do this real quick, this arraignment. While they're bringing him out, I'm doing an arraignment. All right. Are you Mr. Fernandez?
Yes, sir.
Morning, Mr. Fernandez.
Morning.
Sir, you're charged with terroristic threat of a family or a household member. You were facing up to a year in jail and or a $4,000 fine. The reason you're out now is your bond is set at $10,000, which is unusually high for a misdemeanor. I don't know why, but she's asking for a bond reduction. I'd like to know what happened in the case and we'll go from there. Okay.
On March 5th, 2025, an officer was dispatched to a family disturbance type call at a residence in Harris County, Texas. Upon arrival, the officer made contact with the defendant. And the complainant, the defendant's mother, was trying to make him leave the house because she felt like her life was in danger due to his behaviors and threats he made to kill her with a gun. The complainant provided a text message from the defendant's therapist. The defendant also told his brothers about the threats. The defendant showed his 14-year-old brother pictures of guns and stated all of his friends have guns. The brother felt in danger. The defendant admitted he made multiple threats in the past of killing his mother with a gun.
So,
Did I hear a specific threat?
Not directly to the mother, but he had threatened to kill the mom to other people in the
But
family.
That's not, but a terroristic threat has to be aimed to a specific person, and there
Yes.
has to be immediacy.
And my response to that would be that it was aimed towards the mother. Threats to kill with guns while showing pictures of guns that his friends have access to shows immediacy. And to show intent to put her in fear would be a question for the jury of whether he intended to make her feel fear, whether or not it was directly to her or to others.
so I,
Where the threat is.
So, oh man. So he told his brothers that he was going to kill his mother.
Man,
That is what the complainant stated. I don't have a time. Oh, wait. As per mother, the last time the defendant had made those threats was 2 days ago. So on March 3rd.
that's not even.
no, this has to be, it's something where, I'm going to kill you, MF, now. It's not, hey, man, I'm going to do this in a couple of days, when I get up to it, because I'm kind of lazy. I got shit I need to do. It don't work like that.
I understand. I'm just concerned, so.
You gotta be careful. You got one life. How was jail? Sucks, right?
Yeah.
I mean, we're not asking for much. All the knuckleheads that have guns that are running the street, they're going to end up in here one day. That's all. I tell you, don't start asking anybody when you get back to the tank, Really, life is too short to live in a box like this. You don't need a gun. How old are you?
Just turned 18 on March 5th.
You don't need a gun. Get your ass back into school, man. Knowledge is power. You want to make some money? Learn something. She's amazing. Look at her. How much money you make? Don't answer that. She makes a crap load of money because she knows things.
Yeah.
That's what life's about. Fancy vacation, nice cars, big ass beaches, blue water. That's what life's about. But you get it in school by gaining knowledge, not with a gun, right?
Mhm.
I'm gonna find no probable cause. Do something, man.
Sure.
Get back into school, learn something.
He's in school, so he needs to finish school.
Yeah.
Okay,
He's gonna do.
you're gonna get out today. Be somebody.
Yes, sir.
You're not a statistic. All right.
Thank you, Your Honor.
When a
Good morning,
defendant
Judge.
appears with multiple pending DWI cases across different counties, at what point does a judge's duty to protect public safety outweigh the presumption of innocence in setting pretrial release conditions, particularly when the defendant lacks a valid license and insurance?
Good morning, Judge. I got appointed this morning to Mr. Butler, first name Philander. And Your Honor, he has a pending felony case. However, I did see that he made bond on that one, and this is the only thing that's keeping him in custody right now,
What would you like?
Your Honor. And realistically, I talked to him to see if there's any means for his family or friends to go ahead and pay this bond, which I ultimately would be around 100. He didn't provide any information on that. He's actually not sure how he made bond on his felony
You
case.
got a PR bond on it. So it looks like he picked up a UUMV, February 24th. And now he's picked up a misdemeanor theft. I guess they haven't gone back and looked. I don't know what they're going to do. He's set for 331 on that case. I don't know if they're going to yank the bond on that or not. I don't know. But he wants me to give him a PR bond.
Yes, Your Honor. I do have contact information. I have an address for him as well.
Hey, Deputy Miranda, do you mind bringing up Mr. Butler? Yeah. Give me a second. Let me do an arraignment real quick and then we'll talk to Mr. Butler. Good morning, Mr. Butler. How's jail?
Not good.
Great. That makes me happy. Because the harder time you have, the more you have them for a reason. Here's the rub. Your lawyer is asking for me to give you a PR bond in this case.
That's it.
You were on bond for an unauthorized use of a motor vehicle,
That's it.
and now you've picked up a theft case. I have no idea what happened on that theft case. We're going to figure out what happened real quick, and then we'll talk about your bond.
That's it.
You have the right to remain silent. Anything you say can or will be used against you. You're facing a Class B theft, so it's up to 6 months in jail and or a $2,000 fine.
On March 7th, 2025, an officer was dispatched to a theft call at a Target in Harris County, Texas. The defendant was observed on surveillance video placing merchandise in a black suitcase he also obtained from the business and crossed all points of sale without attempting to pay. The defendant was detained without incident. The total value of items stolen was $355.46.
So you said he also has a lot of out of,
No, that was Mr. Phillips.
oh, Mr. Phillips has that account.
Yes.
Miss Keela Lee?
How old is Mr. Butler?
He's 25 years old, Your Honor.
Miss Keela Lee?
Ms. Lee?
And Judge, I was looking, I did not see any sort of history of him not showing up for court or any sort of bond forfeitures on his previous cases.
The problem is you keep picking stuff up. Stop. I don't want you to say, but my problem are two things. Number one, sometimes people are their own worst enemies and they continue to pick cases up that they're just, it can't stop. I don't know. But you, Mr. Butler, you're 25 and you have now 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Now you're on your 13th and 14th case. And a lot of these are very serious felony cases. Unauthorized use, robbery, unauthorized use, felony fraud, evading in a motor vehicle, felony theft. Now another unlawful. Why? Why would we continue to give you PR bonds when since January, you're on your 4th case? Why? The thing that you need to consider, Mr. Butler, is it would only cost literally $100 to get you out of jail right now. And there's no one there to pony it up for. These are the things that you need to consider when you're out there in the free world, because you were in the free world just now and you picked up a theft case. But you need to start thinking, well, even if I pick up a case where it's $100 to get out, I have no one that's going to get me out. Why? Why would we continue to, tell me.
And Your Honor, I mean, as the state mentioned, he hasn't forfeited any of his cases before, although he does have other cases. There's a few that you mentioned that were dismissed ultimately. And he has already provided me contact information. Keep in contact with me so that he's not a flight risk. He is originally from Houston, so he would show up to court.
But I don't want you to pick up any more cases. Right. In the short 2.5 months in this year, you're working your 4th case. I can't give you a PR bond, man. I don't want you to pick up a bill. Bill comes due, Mr. Butler. And now we'll see. I'm sorry. He's working for his 4th case within the last 2.5 months. It's not going to happen. I don't want you to pick up a 5th case. I'm sorry, man. I don't know if you're going to get out now, but if you do, you're not allowed to go to any Target stores anywhere. Do you understand? Okay. All right. I'm sorry, Mr. Butler. I can't just
Thank you, Your Honor.
How you doing, Your Honor? Miss Lee. Miss Lee, you were charged with theft. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have
I'd like to take notes.
Sure.
You said theft, 1 year in jail,
You're facing up to a year in jail
up to 1 year,
and or a $4,000 fine.
and or a $4,000 fine. Proceed.
We're going to do probable cause.
I don't even remember what that meant. I haven't been to court since 2006.
We're going to see whether there's sufficient probable cause to go forward with your case or not.
Okay.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed to you if you cannot afford one. You ready?
What do you call that attorney that's
Court appointed lawyer.
pro bono? Proceed.
Judge, do you mind giving me a cause number? It's not appearing on my docket.
I have,
Please.
oh,
A certain process we follow. I don't want you to engage with them.
I was just,
It's okay. 255. 2005.
So 255-4005.
Correct. And go kind of slow because she's taking notes.
Yes. On March 2nd, 2025, at approximately 2:30, officers were dispatched to a theft at Memorial City Mall at Macy's. Upon arrival, the officer spoke with the complainant, who stated he noticed the defendant conceal a tester of perfumes in her bra. And then a different associate also noticed and asked the defendant to put the perfume back. The defendant did give the perfume back to the associate. Once the associate walked away, the complainant observed the defendant pick up the same perfume and conceal it in her bra, and then later put it in her purse.
I didn't even, in this,
The defendant walked past all points of sale without paying for the merchandise. The complainant stated that 4 tester perfumes were seen being concealed on CCTV footage, and 4, Your Honor. And another 4 were located on the defendant once she was apprehended by a supervisor and the complainant. The total value was $1,321. The defendant admitted to the officer that she did steal the perfume and that she tried to exit the store before she was apprehended.
Okay, what store are we talking about?
This is a Macy's at Memorial City Mall.
Okay. Ms. Lee, I'm going to find that there is sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go back to any Macy's and not to go back to Memorial City Mall.
they've already informed me that.
If I find that you go back to the mall, if I find that you go to any Macy's, I will revoke your bond. I will put you in jail.
Okay.
Please do not pick up any new cases. Likewise, if I find that you pick up a new case, it's not going to go well. Would you like to apply for a court-appointed lawyer, ma'am?
I would, sir.
Okay. So Deputy Miranda is going to give you an application for a lawyer. I need you to fill it out for me. I will have you go to Ramona, sign a reset, and then we'll just have you take a seat wherever you'd like. And then just please fill it out. And when you're done, you can bring it back to us.
Officer Fleischer, I know you did mention that anything I said will be held against me. May I please say something?
Please don't. But let me give you a lawyer first. You tell the lawyer, and if it's
Okay.
appropriate, then they
Okay.
can tell me.
That's-
Okay?
Okay.
But I really don't want you because, but you can tell the lawyer.
I'm sick. I got a liver disease and I can't go to jail.
No one's going to jail today.
No, I mean, I wouldn't live there if, I'm not gonna make it. I have too many health issues, but
Don't worry, man.
thank you so much, Your
We're here to
Honor.
help.
Thank you so much, Your Honor.
Yes, ma'am.
It's gonna be a reset?
Well, I'll have you talk to the lawyer, but most likely it'll be reset. You are, Mr. Salash. Sir, you were charged with terrorist threat.
Amenazas terrorísticas.
You are facing up to 6 months in jail
6 meses en la
and or a $2,000 fine.
de $2,000.
You're going to do probable
Vamos a leer
cause.
causa.
You have the right
Usted
to
tiene
remain
el derecho a
silent.
mantener silencio.
Anything you say can or will be used against you.
Podría ser.
You have the right to have an attorney present.
Pago por eso.
If you cannot afford one, one will be appointed
Uno
to
se le
you.
nombrará. Ok.
On February 9th,
El 9 de febrero del
2025,
2025,
an officer
un
was
oficial fue
dispatched
despachado
to a
a la
residence
residencia
in regards to a
en cuanto
disturbance with
a
a
un
weapon.
disturbo con un arma de fuego.
The officer met
El
with the
oficial se
complainant,
reunió
who
con
stated that
el
he has
denunciante,
ongoing
que declaró que
issues
tiene problemas
with his neighbor
con
over
su
parking.
vecino sobre estacionamiento.
The complainant stated that
El
today,
denunciante
while in his
dijo que hoy,
driveway,
mientras estaban en la marquesina,
his nephew told him to get down,
su sobrino le dijo que se
After
que
he
bajara.
observed the
Después que observó
defendant
el acusado
point a rifle in
apuntando
the
un
direction
rifle
of the complainant.
hacia la dirección del denunciante.
The complainant
El
stated
denunciante
he feared
dijo
for his
que
life
temía por su
and
vida
ran to call the
y corrió a
police.
llamar a la policía.
The complainant's wife
La
filmed
esposa
the
del
defendant
denunciante
pointing
dijo
a
que el acusado
rifle at the complainant.
apuntando un rifle hacia
Officer observed the video
Los oficiales
footage in
observaron
which the
la
defendant
cinta
is
donde el
wearing a white
acusado
tank top
tenía
and black
una
shorts
camisa blanca
while
y
holding what
con
appears to
pantalones
be a
cortos.
black rifle.
Entonces tiene en sus manos algo que
The
parece ser
officer
un rifle.
observed the
El oficial
defendant facing
observó
it in the
el acusado
direction of
mirando
the
hacia la
complainant's
dirección,
residence
la
and
residencia del
positioning himself
denunciante
to aim the
y
rifle.
posicionándose de manera de
The
apuntar
defendant
el rifle.
then
El
disposes
acusado
of the rifle
entonces
in
se
a nearby
deshizo del
shed
rifle
once
en
he
una
realizes
silla
he is being
cerca,
filmed.
ya cuando se da cuenta que lo están
The
grabando.
officer
Los
next made
oficiales
contact with the
entonces
defendant
hicieron
and
contacto
observed
la
the
segunda vez,
defendant wearing the same clothes
observaron al
as
acusado
in the
la
video
misma ropa que
and
estaba
standing
en la
next to the
cinta
same shed.
y corriendo hacia la misma caseta.
The defendant was then detained.
El acusado entonces fue detenido.
The defendant
El
stated
acusado
he did not
declaró
have any
que él no
weapons
tenía ningún arma de fuego,
and then stated
ningún arma.
that the
Entonces
rifle was
dijo que el
hidden
rifle
inside the
estaba
shed.
ocultado dentro de la caseta.
The officer found the
Los
rifle
oficiales encontraron el
and
rifle y
determined it was
determinaron
an airsoft
que
rifle
era un rifle
similar
airsoft
style to
similar
a real assault rifle
a un
and
verdadero
can
rifle de
cause serious
y
bodily
podría
injury or
causar
death.
lesiones físicas muy serias o hasta muerte.
Mr. Salash, I'm going to find that there's sufficient probable cause to go forward
Causas
with the
para seguir
case.
adelante con su caso.
I'm ordering you as a condition of your bond not to have any contact with the complaining witness and not to be in possession of any
No
weapons.
tengo de ningún arma.
Has he since moved? Because I'm going to order
Me preguntaron si se ha
200 feet
mudado
as well, that he not go near the complaining witness.
cerca de
No, Your
200
Honor, he
pies.
still lives in the same
Vive
residence.
todavía en la misma
And
residencia.
the complaining witness actually
Sí.
lives across the street.
Él, de hecho,
And it's a
vive
two, I
acá en la
actually know,
calle.
it's a two-lane, I looked it up.
Y hay de
It's a
dos
two-lane street,
sentidos, una calle
with
de
opposite
dos
direction
sentidos
traffic.
con el tráfico que va
I think it's
por uno al
probably
otro.
outside of the
Yo
200
creo
foot
que está
boundary,
fuera, más allá
but
de
it's
esa,
across the street.
I'm
de 200
not
pies. Ordeno que
2
usted no,
feet of where
menos
this
de
person
200
lives
pies donde vive,
or where this person works.
donde trabaja
I
esa
do not
persona.
want them living in
Yo no
fear.
quiero que vivan en temor.
You understand?
¿Entienden?
Okay.
Okay.
If I find that you violate these conditions,
Si
if I find that you put my public in danger, I will revoke your bond and I'm going to put you in
lo
jail.
voy a poner en la
I
cárcel.
don't know what your immigration status is, but if you're not in this country with
Si no es
permission
este país con
and you go to
permiso,
jail,
va a la cárcel,
immigration finds you,
encuentra.
finds you because they sweep it every day.
Ellos van
They
todos
will put an immigration detainer on
en
you and
inmigración.
you will be stuck in there until this case is over with and then shipped off to immigration. If you were able to get out of immigration on an immigration bond,
Una
you
fianza de
best
inmigración,
behave. Because anything goes wrong,
cualquier cosa,
you will also lose that immigration bond and all that money you've paid
todo ese dinero que has
will be
pagado
someone else's.
será de otra persona.
Do you understand?
¿Entiende? Yes, yes.
You have a lawyer.
Tiene un abogado.
Because you have a lawyer, I will waive your appearance. But it is your responsibility to stay in touch with Mr. Paz and he will tell you if and when you have to
Le
come
puedo
back to
decir
court.
cuándo tú tienes que venir a la corte.
Thank you.
If he tells me he cannot get a hold of you because you were playing games and you're not responding to his phone calls or text messages, likewise, I will
Llamadas,
revoke your bond.
también revoco su fianza.
You
¿Lo
understand?
entiende?
Sí.
Yes.
Okay.
Está
Do you
bien.
mind filing those conditions?
Absolutely.
For now, we will have you sign a reset with Ramona. After that, you will take a seat in the jury box while we get your bond conditions. We will have you sign it.
Fianza, usted le
And
va a
after that, you'll be free to go.
Entonces, después de eso, está libre para irse. Okay,
Thanks.
yes.
Thank you, Your Honor. Thank you for working with us and letting me have time to get out from immigration. May I be excused?
Yes, sir. Thanks. What happened?
No, it's just,
You okay?
yeah, thank you.
Looks like,
It's not convincing.
I know. I mean,
I get over it.
with us here on this
No, it's
case.
just, no, it's not a big deal.
Okay, all right. I don't want to press. Hey, how are you, man? How about that thing with the,
It went well. I did so well, they invited me next. Yeah. It was good. They asked a lot of questions. They asked a lot of interesting questions, even the
good.
It was good.
he was talking about high school.
He was talking what?
It was a high school, right?
It was.
Yeah.
I did a high school presentation about knowing your rights, so I have to
Oh.
focus.
Oh, by the way, did you talk to Greg about that? He has that,
I emailed you about it.
Thomas?
yeah, it
Yeah,
was, it's
I
a,
told him. Yeah. Sometimes they don't put it on the face of it and I have to do a little digging, so I did a little digging. I sent it to
did they have a search warrant or something? They
This
just,
was the warrant, so they got him on this warrant, but yeah.
but they just started taking other things as well?
Oh, I mean, inventory, because they can't take them to the jail judge. I don't know what was taken, but I mean,
A
yeah.
computer,
Oh, I can't.
I'm sorry, or was it an iPad?
He said I had some money.
iPad and money.
Sure, it's in a bag somewhere, but I mean, obviously for a motion to restore, I won't, oppose unless there's something in the computer that's objectionable.
So this is Mr. Carruthers, right?
Yes, Judge, this is Mr. Hakeem Carruthers.
Good morning, sir.
Morning.
So we brought you out today, well, because we're talking about you and it's only fair that you get to hear what we're talking about. Your lawyer, I'm assuming you're asking for a bond.
Yes, Judge, we're asking for a bond.
I don't know. I have to get to know you in about, 2 to 5 minutes, who you are, right?
Yes, sir.
Who you are is not what you tell me because everybody tells me something. Paper really tells me who you are, your past, your present, your potential future, because that's how I get to know you. So I don't even know what you're wanted for. Okay?
Your Honor, he's wanted out of Shelby County in Tennessee for assault, bodily harm, resisting official detention, and vandalism, 10,000 to 60,000. They all arose out of the same transaction where he had a disagreement at a Dollar General store, and he flipped the cash register, and among his damage, he ended up injuring the cashier's hand. And then obviously when officers arrived, it wasn't peaceful. It was indicted on.
Did you say it wasn't peaceful?
It was not peaceful.
Okay.
Hence the resisting. It was indicted on January 17th. In his history, it's going to show a second warrant, but it's only because it was previously charged on September 28th, 2023, and then it was indicted in 2025. That's why it shows two, if that's how it shows up. But it's only one offense. So.
Can't imagine it's even worth it. Really?
So
it's a rhetorical question. You don't have to answer, but I'm saying, Dollar General, man. That's too short. Any priors?
no priors. It's only an extradition because the vandalism is a felony. The other two are misdemeanors. State's not opposed to a bond.
I'm down. Dude, really? All this because Dollar General store. Really? Hope you got it. Get it. Well, that's too short. How long's it been in?
Since last Wednesday.
Wow.
Right.
That's a long time.
Okay. Six, yeah.
So tell me.
The biggest thing, Judge, it sounds like this wasn't indicted until January 17th, 2025. We're at March 10th.
Yep, sorry.
And so there's no failure to appear. So I'm assuming there's not like he's been
I'm
running
okay with giving you a bond.
500.
Well, I don't know about that.
I was gonna say 5,000. For what it's worth, Shelby County did want us to request no bond, but I stated that the court would likely give a bond because of no priors and because it's not an aggravated offense. But for what it's worth, is they were still intending on picking them up. But
What do you think as far as a bond?
5,000, just because of the nature of all that combined to cost $10,000 to $16,000 in damage with just a cat. I mean,
How
obviously.
much in damage?
10 to 16,000. I don't know what it is in center because the sheriff's office there wasn't able to look too far into it. And obviously I haven't called the district attorney's office there, but that's the range because of felony.
Have you do what he can make?
I've spoken to him. He's going to be counting on his family to help him out. That being the case, would you consider 2,000? I think that's sufficient enough to where he hasn't had an opportunity to mess up. Lower, perfect. The lower.
You get but one life, Mr. Carl. You either live it good, you live it bad, or you spend all that time in a box. It's just not worth it over something so silly. It's just not worth it. I'll send your bond at $1,000.
Yes,
I want you to understand, we don't play games, right? We give you 2 weeks from the date of your release to go turn yourself into, you said Shelby County?
Yes,
Tennessee. If you don't do it, there will be drastic consequences. It takes forever for Tennessee to get up here. So if you don't make it up there, you don't turn yourself in, I'm going to revoke this bond. I will set it at 0. I will not give you another one. Do you understand? And then this time I will issue a nationwide warrant. I'm going to get you eventually. You can't run forever. And then this time I will hold you here until Tennessee comes and gets you. You get one shot, do the right thing. You understand? Okay, bud.
The only thing is, Judge, I don't think he signed the waiver or a refusal. So
No, I showed the refusal. I
Signed?
I sent it to you.
Oh, I haven't seen that. The one I saw wasn't signed by anybody. Okay, so he would have to sign a different document first.
No, the refusal stays. He just signs the reset to.
Yeah,
That's it.
because he's a refusal, he doesn't have to sign anything.
Okay, perfect.
Yeah, it stays and he just signs the reset.
Knowing that he's got the 14. Okay,
Yes.
sounds good, Judge.
Okay.
Force I to turn myself in and then go see what they talking about. Because I was down there for a whole 2 years and I went to Lakeside. I was admitted
What
there.
happens is when you go turn yourself in here or over there, when you go turn yourself in, this fugitive case gets dismissed. You don't have to worry about this anymore. Then you just got to go fight that down there, right? But you got to go turn. Is there a bond set there now?
30,000.
So
Once he self-surrenders.
once you go there, at that point, you'll be able to post a bond to get out. And that bond over there is set at 30,000. Okay. And then you can get out and fight the charges on the outside, but you got to go there first. And we have to know that you turned yourself in. Okay. All right. Good luck, man.
Thank you, Judge.
Hi, Mr. D.
Yeah, Judge,
Please.
we want to be transparent with you about this case.
Uh-oh.
It's Gerard Jones. It's a young man that picked up the murder case. We don't know how long you want to carry it or if you want to carry
Is it on docket today?
Yes, sir.
We know that case is going to take years. Right?
Murder case, yes.
And then we have the 2 assault and mischief.
I had actually stayed with they be a minimum to dismiss it and then use it for punishment in the event that he gets convicted.
Yeah, I'm still, I mean, I'm still waiting to hear back. Yes. I had baby off my offer, but I understand Mr. Dixon's point is I wouldn't take anything. I totally understand that. I totally understand that. But I can talk to Fallon. Just gonna ask for quick reason. I don't think the defense will be worse.
I mean, really, don't stress. Life's too short. So you want a week? A week?
Yeah, we could be fine.
So let's set it a week, see what you're okay, and then if not, then we'll set it.
Yes, sir.
You want to talk to me?
Yes, sir. Madam Agriculture, he was, law enforcement. Right now, he's in jail on 2 theft cases, and I was wondering, would you be amenable to giving him a bond on these cases?
Is there not a bond set?
I think it's 5,000 a piece, Judge.
So, yeah, the old one is 5,002. You want me to talk to him?
I talked to him, Judge. He wanted me to, I wanted to see if you, Judge, would be amenable to give him a PR bond. Take that as a no, Judge.
I don't know. Look, I never want to say no.
Yes,
I gotta
sir.
talk to him, but he picked up a theft case, takes off, and the only reason we got him now is because he picked up a new theft case.
That's correct, Judge.
If we give him a bond again, a new bond, are we gonna get a third theft case? You know, I don't know. Let me talk to him and then we'll see.
Okay.
How's jail?
Not too pleasing, not too pleasant.
It's supposed to be like that. Right.
Yes.
Here's the problem. Your lawyer wants me to give you a PR bond. But you picked up a theft case. You're supposed to come to court. You didn't come to court. You took off on us. We issued you a warrant. We issued a warrant. The only reason we have you now is because you picked up another theft case. So why? Why would we continue to do the same thing?
I attempted to come to court, but you see, there's no buses coming out of Kingwood, and I was taking care of my grandmother in Kingwood. So I tried. We tried to get Uber money and everything, but I couldn't make it. And I called in, and
We don't have any record. The only reason we have you now is you picked up a new theft case. What happened on the theft case, Alex?
So on the most recent theft case on March 6, 2025, the officer was dispatched to a shoplifting call at a Walmart. The officer made contact with asset protection, who stated that he recognized the defendant from a previous encounter and observed the defendant grab multiple items in an attempt to leave the store, passing all points of sale without attempting to pay. The defendant stated he is owed a Purple Heart Veterans discount. Therefore, the amount stolen should be less than listed due to the father's military service. The defendant stated he was trying to find his ID that he dropped outside the Walmart, and that is why he passed all points of sale in an attempt to leave the exit. And the defendant further stated that the warrant should be invalidated due to him not stealing on the prior theft as well. The total was $283.62.
it's all not how it went.
No comments on the facts of this case, sir.
Okay.
Was he ordered in the first theft case not to go back to so they're both at Walmart, right?
I want to confirm. No, the first one at a Melrose was the first theft.
Melrose.
Yes, Judge.
It's Melrose.
I believe it's a retail clothing store. So my understanding is.
Are you sure?
Let me double check what that is. Yes, Judge, it's a clothing store.
Do you see any other prior criminal history?
I see only a previous interference that was dismissed, but nothing else besides that.
What do you think, Mr. D?
I think that, I think he would conform to the requirements, Judge. He stated.
Did before.
I understand. He made a mistake there. We all make mistakes in life. He said that he was attending to his ill mother, that, that's not a reason for him not to.
I just turned 30.
What do you do with yourself these days?
I'm a farmer. In the Virgin Islands, I have a farm. I'm a COO of True Farm Hydroponic Goods. We have a farm in Florida, Palmetto, Florida, and we have a farm in St. Croix, U.S. Virgin Islands. I'm trying to expand to make a ranch over here in Houston.
Who do you live with now?
My grandmother, she's battling breast cancer.
Here's the thing. If I give you another PR bond, and that's a big if, I don't want you out on the street because I don't know what you're doing with yourself. I don't know who you have in your life now. So the first thing that I would like to know is that if we give you a PR bond, where are you going to go? If it's out on the street, I'm not going to do this again. But what I'd like is to see, if you don't mind, reaching out to maybe any family members to see who he has there to go home. If you have, you said grandma, if you have a place to stay, then great. We can verify that so that we know that you're going to go. And the next thing is, if I give you a PR bond, I'm going to put a monitor on your ankle so I know where you are, because you're a flight risk. You've already proven to us that you're a flight risk. And so I'm concerned if I give you a PR bond, you're going to take off on me again. And I don't want that to happen, because I'm not going to play this game with you. You know, fool me once, shame on you. Fool me twice, shame on me.
So,
If you already fooled us once, I'm not going to do this again.
yes, sir.
So what I'd like to know is if you have a stable place to stay, and then we'll go from there. So you mind reaching out to see if he has a place to go to? If grandma will take him in, then I will give you one more chance, but it's going to be with a leg monitor, so I know where you are. And if I find that you ever go back to a Walmart again, away go all your PR bonds. You know, you now have no one that's going to bond you out. So the next time someone alleges that you commit something and you end up going to jail, you will be stuck like Chuck in there, because no one is going to post your bond. This is what you need to think about when you're out there in the free world. Do you understand?
Yes, sir.
If I do this, what's going to happen? If I say this, what's going to happen? That's what you need to think about. So let's see what we can do about finding you a place. And then if so, we'll go further. All right?
Yeah.
Okay.
I take care.
Thanks.
In a multi-complainant assault arising from a group altercation at a university, what standards should courts apply to determine whether pretrial no-contact orders and campus bans are narrowly tailored to protect victims without unduly restricting the defendant's access to education and due process rights?
Yeah, since I'm here on Mr. McIntosh, the one we just spoken about the place to stay, I spoke with his grandmother, Mrs. Gladys Sanchez. Mrs. Sanchez informed me that she would be willing to let him stay there for a period of 2 months. If he tries to get a job and stays out of trouble, she's willing to do that. She said she can't let him
That
stay.
sounds fantastic.
She said she can't let him stay there indefinitely. She can't let him stay there indefinitely because he is not on the lease. But she is willing to make a sacrifice
So
of
what
2 months.
Is we'll bring him out, and then we'll give him 2 weeks to see what he's done to get a job. We'll go there. If that's also a condition of his bond as well.
Yes, sir.
You know, we'll put him on prior to release so we know where he is.
Yes, sir.
No dope, no alcohol.
Yes, sir. Fair enough, Judge.
So we know he's not using.
Yes, sir.
That's it after that, right?
Yes, sir.
Deputy, you going? Deputy Miranda. When someone works in jail, do they get paid? Isn't it true they get like maybe 5 cents per hour or something like that?
Somebody know they get like more for 3 to 1, depending on, as a worker, they get more time, more pay. So no, instead of sometimes they do 1 to 1, the workers don't get 3 to 1. That's
But they don't get like any kind of real money, no real money. It's only you're working for time.
So you work pretty much 3 to 1.
What I was going to say is you can either get a job in the real world and make real money, or you can work in the jail. Because if you want me to let you out, there's a couple things you need to do. Number one is get a job. Your grandmother is willing to let you stay there, but not indefinitely because you're not on the lease. So you have a limited amount of time that you can stay there. The other thing that you need to do as part of her condition for you to live with her is you got to get a job. Do you understand?
Yes, sir.
People who don't have anything can't be picky. So don't be picky where you want to work. Any job is a good job as long as you're making at least minimum wage and it's verifiable employment so that we know it's real. Okay. I'm going to give you another PR bond now, but I'm not going to do this again. If you pick up a third case, I'm going to go absolutely bonkers. You know, no one's going to bond you out. So think before you act. You are not allowed to go to any Walmarts. And I'm going to bring you back in 2 weeks to see what you have done to get a job. You must put in at least 10 to 15 applications. It doesn't matter where. Lowe's, Home Depot, McDonald's, don't be picky. You have to get a job.
Yes, sir.
The other thing is no dope, no alcohol.
Yes, sir.
I'm going to test you. I'm telling you now, I'm going to test you on your release so I know that you're not using.
Yes, sir.
You understand?
Yes, Your Honor.
Any questions?
Job.
Job. Drug and alcohol free, and be nice to your grandmother. Because if she's nice enough to give you a roof over your head, don't bite the hand that feeds you, because then your butt's gonna be on the street. You understand?
Yes, sir.
Anything else, Mr. D?
No, sir, that'll be okay.
Okay. You will get a GPS prior to your release, so we know where you are. And I want you back here in 2 weeks to show me what you've done to get a job. If you have done nothing, it's not gonna go well. You understand?
Yes, sir.
Okay, all right. So, good luck, Ms. McIntosh.
Thank you, Your Honor.
Judge, keep the bonds as is, but PR bonds. And then, on March 2nd, 2025, officers were dispatched to an accident call at the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck. The officer noticed that her eyes were low, that her speech was slurred, and that her breath smelled like alcohol. The defendant urinated on herself. The defendant stated that she had one drink and that she was coming from a club. The defendant showed to be lethargic behavior. The defendant confirms that she was the driver and that nobody else was with her. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 6 out of 8 on the walk and turn, and a 1 out of 3 on the, a 3 out of 4 on the one leg stand.
To driving. All we have is her admission that she's driving.
Well, yes and no, Your Honor. We do not have anybody that put her driving. Anybody that sees her in the driver's seat. I spoke with the officer on Friday after we left court. He stated that once he was dispatched, the defendant was no longer in the driver's seat of the vehicle, but the vehicle is on the scene, clearly having front end damage. The officer speaks to the tow truck driver who was there and stated that, and learned that that tow truck driver did not see her driving, but another tow truck driver was there on the scene earlier, and that when there's a lot of tow truck drivers. When the tow truck driver arrived, the other tow truck driver and the defendant were standing outside of the vehicle speaking. So we never.
No one even saw her in the car.
No, Your Honor. However, this is on a major freeway. I can pull up Google Maps if that's good for you.
No, I believe it. I get
There
it.
are 3 lanes to the left of traffic. There are 3 lanes to the right of traffic. There is
How
no
could you
way.
care otherwise.
A way for her to leave without honestly being run over. And that's the case law that I've shown you, that she admits to driving, and that
The problem I also
along
have
with
is-
the conjunction of that, there's no other way for her to get there or to leave. And that is enough to
Was there any
show up.
alcohol in there? Any?
In the vehicle? No, we don't have any open containers.
Did you provide me case law that says that an admission is sufficient?
It's an admission along with corroborating evidence that shows that there's no other person that could have been driving. And
There's one thing, she also denies driving, correct?
Yes, no. So on Friday, when I spoke with the officer told me that she did not outright admit to driving, and that is correct. And through my notes that I emailed him, I put the defendant denied driving. That's not exactly correct. What the officer did say is asked, where are you coming from and where are you going? And she answered those questions. So based on that information, we can say that she was admitted to driving.
I can't say that. That's assuming. You can say, oh, I went there, I went here. I didn't drive here this morning. I took the bus this morning.
She also admits that she was in an accident. She stated that she hit because they're at the same time they're investigating FSGI.
That's new information. I mean,
It's in the body cam, Your Honor.
so I wasn't privy to that. Last week, again, so now we're on her statement only. So I'll wait until they're done. I'm
Oh,
gonna
sorry.
wait, yeah.
No, just that she said that she was in an accident because they're investigating FSGI, and the defendant stated that she hit some sort of. The officer is asking, "Did you hit another vehicle?" And she says, "No, I hit some sort of barrier."
Okay. And then the FSGI, they're unable to charge that case because they can't identify who the driver is.
So the complaint, there's a separate white car that's been in an accident off of the freeway. They're trying to connect this defendant to the FSGI. That driver of that other vehicle, the complainant, isn't able to say who hit her. So we did not accept those charges.
Do you have a case that says that an admission?
Yeah, that's the case. Reed, I sent the email. It's like a 1957 case. The state, they gave you Dansby.
Case from it's a case from 1852.
No, my case, 1957. That's why I was like, everybody knows this, corpus delicti. That's in the state's case. The state cites to Fisher, which is the same proposition that,
Which is the conclusory case?
I'm not sure, if that, no,
The one
no,
that
you're
they're
thinking
saying-
Ford. No,
Oh, yeah, Ford.
yeah, in Fisher, they talk about the corpus delicti rule, which is the defendant's initial.
Traditionally, I agree with you, right? Like, the statement in and of itself is insufficient.
Right. So,
When you have other evidence there, like what she's saying, corroborating evidence, you know,
no, I would dispute that. They're saying that her being on the highway alone, it'd be the other way around. If she was in a parking lot alone, the case they presented to you, it's a lighted parking lot. It's more likely that.
she's in the middle of a freeway.
Right, so it's more likely you're not gonna find someone that's left the scene, as opposed to if you're in a parking lot with lights and street lights, you're probably gonna find that person walking down the street.
Your Honor, we'd argue that if they're in a freeway, there is nowhere for another person to go. The person would not exist.
How could there possibly be someone else? I mean, if you're.
There's all kind of places you can sneak into. There's sewer, jail.
This is why.
You can walk into the store. Yeah, I'm just telling you, I don't know why we're assuming everything they say is like grace. In the case they presented to you, there was a restaurant where the defendant was found. Today, they've said that my client admitted to owning the vehicle. I'm not aware of that. That wasn't presented to me last week.
It's in the dip zone, Your Honor. And the officer did run the car and it did come back registered to the defendant.
So again, that would be from her statement, unless there's some hearsay that they are now saying that corroborates that. In the case they presented, there's a bar nearby that where the person that is the defendant claims they were at drinking. The way it was presented last week is, I went here, I went here, I went here. It was, I drove there. There was no admission to driving. You still wouldn't have a witness to say that she was operating. Did you get my email? Because I want to make sure. Okay,
I'm reading 3 now.
that's the original one. Yeah.
What's the
holding?
Is it still good?
Yeah. There's nothing.
Have you seen 3?
Sorry, Your Honor?
That's the one I sent.
Did you send it to them?
I have seen them all, yes, Your Honor.
And it's an oldie but goodie. That's exactly the same situation. And then
No, it's like right on point. It's like here we have, except for the fact that like in 3, he's at a hospital, makes an admission, where here, she's still on the scene.
And see, that would be our.
she's in a record car.
Okay, I'm meaning, but she's still
They're right next
close to the car.
And that was our argument, is that distinguishing 3 from the case that I presented to you is that in 3, the defendant's not on the scene.
How-
Somebody else could have driven. As opposed to the case where I showed you, which showed defense counsel and you as well, Your Honor. It is a Whataburger parking lot, I believe they're in, maybe a
Right.
McDonald's. It's a fast food restaurant. The defendant is found inside the restaurant and the car is outside of the restaurant. But the court found that based on the totality of circumstances, looking at the surroundings, that the defendant's admissions combined with the fact that it was his vehicle, that he was right there, that it was enough to prove operation.
Yeah, that's the distinction that I think, is important, because all of that is near itself as far as premises and the defendant. Everything here is not near the scene. It's not all one little package. I don't know where she
Why
went.
not? What do you mean? Why not? The only difference here is that she's sitting in a record truck, but we have.
No, they said that she went to all these places that I don't know where they are, or if she went, and so in this case, they have evidence that she was
So
going.
the officer, hey, where were you coming from? Where are you going? And she says, hey, I was,
Coming from a club.
dancing.
Right, whatever. In San Antonio, I don't know. I don't know where that club is. That's what I'm saying. And here, they know where the water.
Is it relevant? Where? I don't care. My only concern is she driving.
Right.
I don't care where she goes.
Exactly. And that's where, again, she's not saying she drove there. She's saying that she was there. So
She's saying that she was going home, Your Honor.
someone was driving her home.
What's the exact statement that she says?
Don't have it was on the body cam, but I have from the offense report, if I can pull that up.
Why don't we put it off till tomorrow so you can take a look at what she's looking at? That way you can make an informed argument, Are you okay with that?
No, I'm good anytime. I like to postpone always. So I'll come back tomorrow.
I asked the suspect where she was coming from. She stated Good Moods, a club in Houston, Texas, and that she was going home.
So I go home, someone asks me, where are you coming from? I'm coming from the courthouse. Okay, they don't know that I took the bus there, back home. You know what I'm saying?
But she's alone. Her car's in a ditch.
I don't know, again. I got your, or
I
I
mean,
see.
take a look. We can finish it up tomorrow. I'll take a look. If you have any more cases, just
But I
let me
do
know.
agree with you that that case is on point. And then I do want to point out that from last week to today, and I'm assuming tomorrow, the facts are going to keep getting different, you know.
So take a look and take a look at everything. Release everything so that
I
you
have,
can
yes, Your Honor.
absolutely every single piece that's out there.
I got you.
See, yeah. Okay, Mr. Pond, thanks. All right. So gentlemen, both of you guys have worked out agreements in your criminal cases. You've worked out an agreement where, Mr. Jones, your case, you're charged with criminal trespass. Both of you are charged with criminal trespass. Yours, Mr. Jones, it's elevated to a Class A misdemeanor because it's a trespass of a habitation, shelter, superfund, or infrastructure. So you're facing up to a year in jail and or a $4,000 fine. But you have worked out an agreement where they're offering you 39 days in jail with credit for the 3 days that you've done. As a result of this plea bargain, they're going to dismiss 3 other cases. Is this how you understand it? All right. Mr. Smart, you have worked out an agreement where you are entering into a 2-year deferred adjudication. This is a type of probation that if you complete it successfully, you will not end up with a conviction on your record. You need to understand you give up nearly every right known to man by entering into this agreement. If you violate this agreement, then we will issue a warrant for your arrest, put you in jail, and you're looking at up to 180 days in jail. But I'm telling you now, we will continue to do this treatment program until it takes. If you take off on me, if you don't complete it, if you don't do the aftercare, I will issue a warrant. I'm going to put you back in jail and we will start the program new and fresh every single time until it takes. Do you understand? The only thing I'm asking you to do is stay clean. That's all I want. That's literally all I want. Don't kill yourself slowly. Don't kill yourself at all. Do you understand? You must do substance abuse treatment as indicated by the TRAS that you have done. You will do what's called SAT. This is an inpatient facility that you're going to go to. The program lasts around 9 months, give or take. It depends on how well you respond to treatment. If you do well, if you do what they ask, then it goes shorter. If you fight with them, it's going to take longer. It could be a year and a half. Do you understand? So both of you give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Now yours will reflect as a conviction on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? Mr. Smart, if you complete this, you do not end up with a conviction on your record. You understand? How do both of you plead to the offenses, guilty or not guilty? I'm not going to find you guilty. I'm going to withhold that for 2 years. You're entering into this probation, and I'm telling you, all I want you to do is be clean. Can you get it done? Yes. I really, really hope so. We're going to keep doing it until it takes, one way or the other. Did you have anything that you wanted to add?
That's it,
No?
Judge. Thank
Okay.
you.
Anything?
I'm gonna wait to see.
I'd like to go through Mr. Smart.
Okay.
So maybe like 4 months in,
Okay.
let's go pay him a visit. I'm going to go visit you to make sure that you're doing well.
Yes.
You're not going to treatment. If you're going to treatment, I'd visit you. And I don't even know where you're going to go. Good luck, gentlemen.
Thank you, Judge. Yes.
Thank you, sir.
Yeah.
Judge Fleischer, she wants to thank you.
All right. Just make us proud.
Yes.
Make your sons proud, Mrs. Smart. Thank you. Good morning, Mr. Torres. Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 50 days in jail with credit for the 2 days that you've done. You need to understand that this charge is going to go on your record. It's going to be there for the rest of your life. It's even there after you die. This is important because if you ever get pulled over again and you smell like alcohol, you smell like dope, what's going to happen? Up to 10 years. Cops don't care if you're falling down, stupid ass drunk. You don't have to be like that. Just the faintest smell of alcohol. You get pulled over, an officer's going to run your license. They're going to say DWI, DWI. Well, he's probably DWI again. Put him in 2 to 10 in the penitentiary next time. If I were you, even if you've had a sip of alcohol, I wouldn't get into a car. It is a huge risk. Not to mention how much money you paid for all this. You know what I mean? $40. Uber will take you anywhere you want to go. Don't matter where you want to go. $40. Use it. You have the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on record. You can never take it off. Do you understand? Yes, sir. I didn't plead to the offense guilty. I'm not guilty. Yes. I'm going to find you guilty. I have to suspend your license. I will suspend it for a year. Do not drive until you get a license. Now, when did he want to report for the jail time?
The 24th, Your Honor, 2 weeks from today.
Okay. You must report by 6 p.m. on that day. If you fail to report, I will issue a warrant for arrest. And then you're looking at up to a year in jail. Do you understand? So to report by 3/24 at 6 p.m.
Your Honor, I don't know if I don't want to interrupt you, but just regarding court costs, if you would consider running them concurrently. I was retained, but Mr. Torres is in, I believe he's on SSI, he's on disability. And he also uses Medicare for his insurance. He's not working because he has a.
You know, in life, we are allowed to make mistakes, right? But when you continue to make mistakes where you endanger other people's lives, everything gets just so much worse. You know, I routinely, when I have a DWI first, I routinely run court costs because there's also a surcharge on your license of $3,000, perhaps $4,500 if you have a high breath test. It's a $6,000 surcharge on the DWI second. Why would I continue to reward you? What do you do for a living, sir?
I'm a stay at home.
You don't work? What's the nature of your disability?
From the car accident.
He has it's a broken.
Because of your car accident in this case?
No, previous one.
Previous.
He had one in 2011, Your Honor.
And now we're here on a DWI second. Was it due to another DWI?
Yes, Your Honor.
When do we learn? When do we learn? What is it going to take? A death? Lose a foot? What happened in the accident? Holy crap. Are you lucky to be alive?
Sure.
And here we are yet on a DWI, a new DWI. I'm suspending your license for 2 years. I don't want you anywhere near a car. Don't drive. You scare me when you get into a car. You're lucky to be alive. Much less, what about the rest of our, what? You know, my family's on the road all the time. I had a good friend a year ago die from a DWI. What? The reason that we have all these surcharges are because sometimes jail is not enough to get your attention. So now the legislature has made it to where somehow we got to get these people's attention. So let's just start hitting them where it really hurts, and that's in the pocketbook. This is a $6,000 surcharge, not to mention court costs, $6,500 that you'd be rolling out of here with. What do you think? They want me to roll the court costs. I will make you a deal. I want to see something proactive because I'm not sentencing him yet. I can continue to sentence until the 24th of this month. show me some proactivity so that we know it's not going to happen again. And I'm happy to roll the full cost. But I want to see something proactive from you so we know that you've learned something. Don't write me a letter. I get enough letters. I don't need a letter. I want something really proactive on your part that shows me that that it's not going to happen again. We're not going to see that you've learned something from this. And if you can be proactive, show me something, then I'll waive your $6,500 in fines and fees. And this is important because if you don't pay it, every $100 you owe, you will sit 1 day in jail. So you can imagine how long you will sit on a $6,500 surcharge. You have 2 weeks to really knock my Aunt Connie's socks off. Do you understand? Okay.
Okay.
All right. 2 weeks. Yep.
Janice?
Yep. Here. Stop. Please don't kill someone on our roads. That's all I'm asking you to do, man. Every single day. We have an intox man. Good morning, Mr. Martin. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 8th, 2025, officers were dispatched to a weapons call at 821 Custer Street in Harris County, Texas. The caller stated that there were about 10 people fleeing, and the caller saw a gun. The officer observed a multitude of people walking from the street into the property and saw the defendant fitting the description as the person with the gun. The officer approached the defendant, and he admitted to having a gun on his person. Upon the frisk, the officer felt the outline of a firearm in a crossbody bag on the defendant's person. The officer removed the handgun from the bag. The defendant is 19 years old.
You doing wrong? Hold on. All right, I'm going to find no probable cause in your case, Mr. Martin. Be careful. You know, you're 19, you have a gun. God forbid you use it. Put yourself in such a deep hole. You know, really. Go to school, get some knowledge, get a good job. You'll get a ton of money, and then life's great. Life sucks without money. I promise you. Don't end up in a hole, hang out with dogs, because all you're going to do is get fleas, you know? Take a seat, please. Good morning, Mr. Wolf.
Good morning, sir.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 7th, 2025, Officer 1 was dispatched to check by a unit at the 3800th block of Revel Street regarding a minor crash. Officer 1 made contact with Officer 2 who on-viewed a two-motor vehicle accident. Officer 2 observed the defendant operating a silver Ford minivan and crashed with a black Honda Santa Fe. Both drivers were moved to a gas station. The witness observed the defendant driving the silver minivan and stated she observed the defendant crash into her. The officer observed the defendant to have bloodshot, glossy eyes and sluggish speech and poor balance. SFSTs were administered, 6 out of 6 clues on the HGN, 5 out of 8 clues on the walk and turn, 3 out of 4 clues on the one-leg stand. The defendant was placed under arrest and read the DIC, and he consented to provide a blood specimen. No.
Prior to your BI, just the one from with us or any more?
It looks like there is a pending DWI from Galveston County from back in 2021.
Can you please confirm whether that is actually pending now? Because I'm going to have big issues if that is actually pending. Please. I'm going to find that there's sufficient probable cause to go forward with your case, Mr. Wolf. I'm ordering you now. Just take a seat for me in the jury box. I'm not ready to go forward. I want to know if you have an open DWI. Come up, Mr. Wolf. Guys, I have found that there's probable cause to go forward with your DWI second in here. You also have another DWI in another county. Stop.
Okay, that was driver without license. Yes, sir.
I don't want you to say anything. I will appoint you a lawyer today, but it's unacceptable that you continue to pick up cases here, there, everywhere. Unacceptable. And I don't think that a PR bond is the right thing to do. I'm now going to revoke the PR bond and he goes with you. You're a danger to our community. That's unacceptable.
Just driver.
Stop. I will appoint you a lawyer. I don't want you to say anything now. I would like, did you talk to a lawyer? Can you appoint someone, please? You are not to drive at all. I don't care what you're going, what you need to do. Do not drive. The only thing I'm asking you to do is please don't kill someone on our roads. That's all I'm asking you to do, man. Every single day, we have an intox man, an assault that happens because of this. Stop. There is probable cause to go forward. We have trials to determine that, but I have found that they're sufficient to go forward. You've got multiple cases open in another county. Goes with you. I will appoint your lawyer, tell your side to the lawyer, and then we can talk after. Ready?
Judge, may we approach on go on Mr. Wolf?
Okay.
Your Honor, I mentioned information, so we did look it up on that case. Olson Galveston, that it was active. We just looked it up on their public records, and that DWI, the same cause number on the NCIC was the
But he still has open Galveston cases.
Still has open Galveston cases there for, I guess, possession of marijuana and a driving without a license. So those are the two, the DWI is not.
Did you want to bring him out?
He's over an 8. And Judge, I did not talk to him all about the facts of his case, and normally I do before I approach. I just wanted to reapproach on the bond, so.
Yeah.
I've already told him I'd make an appointment to talk to him.
Have you run his license?
He is not eligible. That's too much.
Yes, probably so. You said he does have, charges in Galveston? Possession?
Someone left it back. Left it over for
That's, yeah, so.
Let me make sure. Let me make sure.
Yes, ma'am. That's what.
It's okay.
I take probation. I got an ankle monitor or something. I got a job and all that. I was thinking and I was trying.
I'm gonna help you, but let's try to get it, let's at least try to get it lowered to get you out today.
I'm going to do everything in my power to protect my community.
Yes, sir.
At all costs. I don't care who you are. I don't care what color you are. If you're a small farm animal, everything in my power to protect my community.
Yes, sir.
You have 2 open cases in Galveston, and now you've picked up a case here. Does he have a license?
It's not eligible.
You are not allowed to drive. You will be signing an affidavit with me today, promising me you're not going to drive, Mr. Wolf. And I want you to understand and hear me crystal clear that if I find that you drive and I don't give a rat's behind what your excuse is, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every single time you drive. I don't care that you need groceries. I don't care that a kid has to go to the hospital. I don't care that there's a burning building and you have to save 50 kids. If you don't have a Texas driver license and liability insurance, then you're not to drive. You now stand charged with the DWI second in this court. I am now also placing an additional restriction on your license that you're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle and it doesn't have an interlock on it, because I send notice to DPS in Austin so that every police officer in this state knows you get pulled over, you don't have an interlock on that car, they will take you directly to jail. I'm going to honor your PR bond today, but I'm putting a whole host of restrictions on you. And if I find that you violate these restrictions, I will violate that bond. Do you understand?
Yes.
You are not to consume alcohol, illegal drugs, and I'm telling you, I'm going to test you within the next couple weeks to see whether you are using. If 50 plus days have passed and you test positive for marijuana, it's not going to go well for you. Do you understand?
Yes, sir.
The only thing I care are my streets and that they're safe. And if you don't have a license, and you ain't got insurance, then you're not gonna drive. You will now get a portable device that you're gonna take everywhere you go to prove to me that you're not using alcohol. And I'm telling you now, I'm going to test you for weed here momentarily. Hey. They filed 2 surrenders on Mr. Galvan's case. I just need to know your position. I sent you a picture of it. Can you just take a look and let me know what you say? Correct. Okay, I just wanted to know. Okay, thanks, Jim. All right, take care. I'm honoring our bond. I'm letting you out. You hold the keys to this jail cell. You know what's expected of you. You pick up a 4th case. I'm going to go cuckoo for Cocoa Puff on your bond. Do you understand? We have also given you a lawyer. It is your responsibility to stay in touch with her. If she tells me she can't get a hold of you because you've gone AWOL, you've taken off, picked up a new case in another county or whatnot, that's it. A card before you take it. Oh, okay. Thank you. We'll have you come up here, swear to that you're not going to drive. I will get you to Victoria where you will sign a reset. You will then get with Fleischer for your bond conditions, and then you guys can talk about this case. Don't pick up a 4th case. Okay? All right, Ms. Teach.
Judge, may I be excused? I've made arrangements to talk to him about his case. I'll give him a call.
You ready?
Who's
rocking now?
Judge, was this one THA?
No, I gave her an application.
So the smoking jacket,
You did. It's okay.
Smoking.
Well, it's too early, man. Come on up, sir. Is it De Los Santos, you said?
Yes. It was under Santos.
It's page
On the
19.
docket, but it's.
I see it. Got it. All right, Mr. De Los Santos, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high blow. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On March 9th, 2025, at approximately 6:34 a.m., an officer responded to a major accident on the 6100th block of North Fry Road in Harris County, Texas. The officer made contact with the witness, who was traveling south on North Fry Road and stopped at an intersection of West Little York Road, and he began to drive. When the light turned green, he was struck from behind. He exited his motor vehicle and observed the defendant in the driver's seat. The officer observed rear damage to the witness's motor vehicle. The witness stated the defendant was transported to the hospital. The officer observed heavy front damage to the defendant's motor vehicle, but no closed or open containers in his motor vehicle. The officer made contact with the defendant at Katy Memorial Herman's Hospital. The defendant stated that on March 8th, 2025 at 6 p.m., he was drinking at a friend's house. The defendant stated he drank until 4 a.m. the next morning. He admitted to driving under the influence, resulting in a major accident. The defendant had visible scrapes and injuries on his face, arms, and legs. The officer observed the strong odor of alcohol upon his breath, red bloodshot eyes, and slurred speech. SFSTs were administered. 6 out of 6 were observed on the HDN. The walk and turn and one-leg stand could not be conducted due to injuries. IVs, and the defendant had IVs and the defendant was wearing a neck brace. The nurse checked his vitals and ensured the defendant was in good health to be discharged from the hospital. The defendant was read the DIC and agreed to a breath test. The results were 0.166 and 0.169.
How long from the time of the accident to the time that he goes to the hospital? Is it immediate?
So I don't believe it states what time the accident occurred and what time he was transported to EMS, or transported to the hospital, but it's before the officers were able to arrive on scene and do an investigation of the accident.
He doesn't write down what time the accident is? Do you have the OR?
Been a lot of that going on lately in Dennis.
I don't understand who's writing these reports.
I don't know, I thought it'd take us
No,
to
I don't get it.
improve on January.
It is, it's important to know how long it takes him to get to the hospital, right? And then I guess he's discharged immediately after he gets to the hospital. I mean, that can't be because he does, how long does it take to get into an emergency room? It takes forever. When I have a family member that goes to the hospital, it takes 12 hours just to get seen. And then he goes and he blows a 16 after. I mean, No, look, I'll give you a little bit of time. Take a look to see.
And getting, hopefully the office working clear up. We don't have that back yet. Correct.
I just want to know that there's not a disconnect. Like it doesn't take 12 hours to get from here to here. Because you know how long it takes to get to hospitals and it's ridiculous. So yeah, I'm gonna put it on hold for now because we got a whole.
Today or?
No. Later, like I'll give him a couple, like maybe an hour or so. Do you have anywhere else to go?
I have plenty of places to go.
I bet. So go do what you need to do. Come back. Let's revisit PC in a little bit. Will you?
Absolutely.
Okay. Take a seat from the juror box, please. And then I think that we need to do a name change because they have it under Santos, but his name is De Los Santos. De Los Santos is the last name, not just Santos. Nathan, and it's De Los Santos.
That's correct. All three separate.
Name change. Right. But it starts with De Los Santos. Right. So that's, yeah, we're gonna do a name change. Okay. Are you ready now or do you want some time to look?
Can we, yeah.
Can I make a suggestion? Based upon the offense report not having any witness stand here, and then Jim's report not having the information that they're seeking, I think at this time, no problem cause finding is appropriate. However, it's my understanding that Chief Pace, since I trained him, will probably go and figure out all these facts and get it refiled correctly.
I wanted to give you a little bit of time. If, you know, huh?
And we already.
I didn't want to go that far. I wanted to just see what the report has.
And the,
You know, because you being able to go contact the officers a little bit just beyond this, you know, because it's not fair to them. But what I'm looking for is how long it takes from the accident to get to the hospital, you know, to see, is it him that's driving? Is he intoxicated at the time of driving? Because that's what it calls for, right? That's what we need to know. So if you can just take a look real quick, go do what you need to do. Come back maybe like 45 minutes. I just want to know what the timing.
I was just going to suggest we already have a date of 4/14 that they could get this done in the interim and not have to scramble today with 50 other arraignments. That's all I was suggesting.
and
But it's up to the court.
looking at the OR, the timeline is not.
It's not in
OR
there.
for that.
They didn't put any time in the OR.
The times that I have is that the witness said that they had been there since 6:30, sorry, I don't know what that is about. But, the only time that I have is that the blood sample was taken at, 8.
He didn't write time. He didn't write down what time the accident happened or what time he gets on the scene. There's got to be something, you know? Look at the MDTs. There's got to be a time where.
I'm looking at the wrong offense report, Judge. I apologize.
It's okay.
I do have based on the accident report, the crash time was 5:50 in the morning. And I'm not seeing, we don't have your honor, is the time.
I'm not concerned about that. I'm concerned what time he gets to the hospital. Crash occurs at 5 something in the morning.
Okay. And
Does he get to
he
the-
went into the emergency room at 7 a.m. So it's roughly about an hour.
Well, he gets admitted at 7 a.m.
Yes.
Okay, so we're about an hour and a half after the crash. What time does the officer get there? Start interviewing, do you know?
The crash is at 5:50 a.m. The officers transport the defendant at 6, so 10 minutes later.
They transport him to the hospital?
Yes.
Okay.
It's admitted into the emergency room.
What time does the officer get there to start the interview? Mr. Beadle, I just want to know that everything is in close proximity because if he gets there, he starts interviewing like 12 hours later, I'm gonna have a problem.
And I think the DIMS will probably be supplemented appropriately. I know how much business you have today. I see all the arraignments here sitting in the audience. I think that they will get it done by the 14th of April, which is what I already have the date for. But I leave it to the court's discretion. I'm fairly certain it's not in there. You're doing great, by the way.
I don't see a time. It just needs to find out right on the possibility.
And the blood draws what time?
It's at.
For the breath test, sorry.
Which is weird in and of itself, Judge, because they said he couldn't do the one leg stand or the walk and turn.
Because
but then they took him off to another location to do a breath test. It's just kind of weird.
doesn't say that.
You don't even have time of the breath test?
So it looks like if you look at her I would ask you that what she would leave up to review it before.
What do you think? We have a date for the 14th. I'm sure they'll do it before then. His appearance is waived anyway, so he doesn't have to be here.
Okay, so.
Do you want to put some potential conditions on
No, I
him,
agree.
assuming? Okay.
So I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. Any prior DWIs? And valid license?
No prior DWIs and his driver's license is valid.
Okay. As long as you have valid liability insurance and a Texas driver license, you may continue to drive. But if you don't have car insurance, do not drive. It is a condition of your bond. Don't consume alcohol. Don't use illegal drugs. Do you understand?
Yes, Your Honor.
I will waive your appearance while you're on bond in this court, but you must stay in touch with them. If they tell me they can't get a hold of you because you're ducking and dodging or you pick up a new case, all bets off. I will put you in jail. You understand? Okay. I'll have you sign a reset with Victoria. We'll get you with Felicia your bond condition, then you're free to go. All right. Mr. Beadle, always a pleasure. See you Friday.
Have a great weekend.
You too. Good morning, ma'am.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, ma'am.
On March 9, at approximately 3:14 a.m., the officer observed a vehicle driving without taillights and swerving its own lane side to side. The officer observed the vehicle failed to maintain a single lane and merged into another lane, almost colliding with the vehicle in that lane. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and she was identified by her Texas driver's license. The officer observed the defendant have bloodshot eyes, further speech, and odor of an alcoholic beverage on her breath and person. The defendant stated that she had 2 tequila drinks. SFSTs were conducted. There's a 6 out of 6 on the HGN, 4 out of 8 on the walk and turn, and a 2 out of 4 on the one leg stand. The DIC was read and the defendant consented to breath. The results were at 0.137 and 0.132.
Okay. Ma'am, I'm going to find that there's sufficient probable cause to go forward with the case. You also look prior to WI's license, please.
Yes, sure.
I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
There's all the testing, what is that? Pass on that message.
Just random testing. No alcohol, no dope.
Okay.
Illegal drugs.
I guess just so I can pass it on, if there's a pattern of nothing, can he reapproach in the future?
Of course. It's gonna, I mean, don't come in 2 weeks though.
No.
Right. But yes, of course.
License is eligible, no prior DWI.
Okay, so you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you when you have to come back to court. As long as you don't pick up any new cases, we'll be fine. I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions, then you're free to go, man.
Thank you very much.
Have a good day.
When the only evidence of operation in a DWI case is the defendant's extrajudicial statement and no witness observed driving, does the corpus delicti rule require independent corroborating evidence of the crime itself before probable cause can be found?
Have a good day.
Yeah.
Good morning, Mr. Robinson.
Good morning, sir.
Sir, you're charged with terroristic threat. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. So, okay.
On March 7th, 2025, in Harris County, Texas, at 315 Capitol Street in Houston, Texas. The complainant is a security guard for the building and was walking around Bagby when he found the defendant sleeping on the sidewalk. The defendant was not supposed to be there, and the complainant told him repeatedly that the defendant was not allowed to be there until around 11 a.m. at night. The defendant then began to get hostile and aggressive and threatened to shoot the complainant while slowly reaching into his bag. The complainant feared for his life.
Did you say he's not allowed to be there until 11 p.m.? Did I hear you say that? What is
I don't know. We did not charge a trespass in this case. So when the complainant said, we never leave at 11, that's when the response.
What did he say again?
The complainant repeatedly told the defendant that he was not allowed to stay there until after 11 p.m. to 7 a.m. And since it was before 11 p.m., he was there for trespassing and not allowed to be on the premises. The defendant had threatened the complainant that he was going to get his gun and shoot him by signaling this might go in his bag with the complainant field first.
He said, I'm going to get my gun and shoot you.
I don't know if it goes by say the defendant defendant threatened the complainant that he was going to get his gun and shoot him, signaling this by going to his bathroom.
Who wrote the report? The actual officer who got threatened or someone else?
The officer did not write the report. I mean, the officer wrote the report on the security guard. The security guard was the one who was threatened.
Mr. Robinson, I'm going to find probable cause for now. Okay. Let me give you a lawyer. Talk to the lawyer. Just don't have any contact with the security guard. That's the only thing I'm going to ask you to do. Right?
If I might say real quick, I know you're busy. They have a city ordinance. That's why you can't lay 11. But I was recently jumped. I got my medical records.
Look, don't tell me because I've got a bunch of DAs. I don't want you to say something that hurts the case. Let me give you a lawyer. Everything you say, when you want to tell me, tell the lawyer, and then they can tell me what.
I understand.
Okay.
Because the defendant works this location and we're not in contact with this location.
What is this? What is this place?
It's an hospital in downtown.
That's the top. That's where I was at.
Don't go back, please. The problem is I don't want you to run into the security officer. Then more bad blood comes up. They found more charges. That's why.
I understand. I never said that I ain't tripping. I already filed a motion for discovery inspection. I didn't even have a bag on me.
Don't worry about it. We'll take care of you. I'll have you sign your receipt, Victoria. We'll have you take a seat. Let me find your lawyer.
Yes, sir.
Okay, please.
Right this way.
So if you can file this, please, the condition. No going back. Sorry?
Whenever you're ready to talk.
Yeah. I thought I signed it. Yeah, I signed it already.
You didn't vote it now.
Yeah, so we can get them out. Mr. Lechuga, come up. We'll have you sign your condition. We'll get you out. You, Jessica Araiza? Araiza, come on up. Araiza, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Okay.
Okay.
On March 9th, 2025 in Harris County, Texas, officers were dispatched to a suspicious person call. Officer met with the witness who stated that the defendant was looking for her children and was at a nearby residence. The officer then made contact with a complainant at the residence who stated the defendant had been intoxicated at a family gathering earlier and they began to argue at home before the defendant assaulted the complainant. The defendant admitted to striking the complainant with the television. The officer noted the complainant to be bleeding from his face. The complainant is her ex-husband.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to have any contact with this complaining witness and not to be in possession of any weapons. Do you see a protective order that has been issued in this? Okay, ma'am, I'm issuing now what's called a magistrate order for emergency protection that identifies Mr. Roberto Baron as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You know, stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes.
If you violate this court order, the state can and probably will file a violation of protective order. That is one of the worst cases you can pick up. Just don't have any contact. Don't use alcohol, any dope. You'll be fine.
Okay.
Just, I'm going to protect my city at all costs. And if that means putting you in, I'm going to do it in a heartbeat.
Okay.
Now, do you have the ability to hire a lawyer, man?
No.
Do you work?
Yes.
Okay, you work full time?
Yes.
Okay, I'll have you fill out an application. Do you have any children?
I have 3.
Okay, I'll have you fill out an application. Let me take a look at it to see whether you qualify and then we'll talk. Do not leave until you sign our bond conditions though. Don't worry, because since she'll be monitored for no alcohol, we'll have Felicia do it. Okay, please. Deputy Miranda will give you an application. Good morning, Mr. Lechuga. So you're charged with displaying a fictional license is a plate, right? That's it. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7th, 2025, at approximately 6:32 a.m., an officer observed a vehicle with expired registration as of June 2021. A traffic stop was initiated. The officer ran the license plate and it returned to a different vehicle. The officer made contact with the defendant, the sole occupant. And the defendant stated he purchased the vehicle 7 months ago and had not been able to register the vehicle due to long work hours. The defendant was detained and the defendant stated he had already received a citation for displaying a fictitious license plate by the LaPorte Police Department in January of this year.
Okay. Can you run his license, please? Does he have a license? Mr. Lechuga, I'm going to find that there's sufficient probable cause to go forward with your case. I am placing conditions on your bond now that you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name, car insurance. God forbid you get into an accident and you maim someone and they come after you and sue you for $50,000. Got to hire a lawyer. You'll never crawl out of that hole. That's why you get car insurance, because you're not on purposements or accidents for a reason. When you have insurance, they represent you. They'll get a lawyer for you. That's why you need it. If you don't have it, don't drive. Do you understand?
The driver's license is available.
Okay. So as long as you have those two, you may continue to drive. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Casanova Mission. They'll tell you if and when you have to come back to court. She tells you that you pick up a new case, you start acting a fool in the free world, I will take it away from you. All right, I'll have you sign a resale with Victoria and then we'll get you out of here. Thank you. You were on bond for an assault case that have taken off on us at least 3 different times, and now you've picked up a new case. You were charged with failure to identify oneself while being a fugitive from justice. On that case, you're now facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can will be used against you, sir.
On March 7, 2025, at approximately 4:44 p.m., an officer observed a vehicle with expired registration as of December 2024. A traffic stop was initiated. The officer made contact with the defendant. The driver advised he did not have any form of ID on his person and provided his name is Daniel Escamilla, date of birth April 24th, 1998. The officer did a search and saw the defendant did not resemble the Texas driver's license that came up for Daniel Escamilla. The officer got a hit for David Escamilla, the defendant's real name, and saw there was an outstanding warrant. The Texas driver's license photo for David Escamilla resembled the defendant. The officer utilized mobile AFIS and confirmed that the defendant was David Escamilla. The defendant admitted to providing the officer with his twin brother's information instead of his own due to the open warrant.
Do you see if he has a license? Can you check, please?
Yes, it's ineligible, Judge.
Okay, Mr. Escamilla, I'm going to have you sign an affidavit with me today. I don't give a rat's behind what is going on in your life. If you don't have a Texas driver license and liability insurance, you are not to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Yes, sir.
You have a lawyer, Mr. Escamilla.
No, sir.
I'm going to appoint you a lawyer today. Your assault case is 1,000 days old. We are going to figure out what happens with this case today. Can you appoint him a lawyer, please? If this case gets reset today, you will get an ankle monitor, and I'm going to send you for a drug test right now. I want to ensure that you're not using anything as well. You know what? Let's just do that now. Police, if you can send him, please. If you fail to take the test, if you fail to come back, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, sir.
The next time you take off on me and fail to come to court, so help me on those bonds. Do you understand?
Yes.
Take a seat for me. Joseph Martin?
Yes, sir.
So, Mr. Martin, you have a total of 4 open cases. You're charged with 4 counts of assault. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 8th, 2025, officers were dispatched to 4527 Perry Street in Houston, Texas, in Harris County regarding an assault. The complainant, Hayes, stated that she was in a verbal argument with the defendant, and that led to her being pushed by the defendant. Complainant Hayes said that she hurt her hand due to being pushed into a car with the defendant and that she felt pain. The complainant, McDaniel, then stated that she confronted the defendant to see if her friend getting assaulted by the defendant. The defendant then started swinging and struck the back of Daniel's head, and that complainant felt pain as well. Complainant Powell then stated that she was assaulted by the defendant due to also trying to defend her friend, complainant Hayes. Complainant Powell says that he approached them to confront the defendant, and the defendant just started swinging and that she got struck by the defendant. Complainant Powell stated that she does not recall how that she was hit, but that she felt pain. Complainant Martin stated that she knows the defendant from school and they both attend TSU. The complainant Martin stated that she was trying to calm the defendant down but does not remember the physical assault due to her being knocked out unconscious by the defendant. Complainant Martin felt pain. A witness stated that she saw the whole incident and saw that the defendant was arguing with complainant Hayes and that the defendant started pushing complainant Hayes into a vehicle. Complainant Martin was then trying to de-escalate the situation and stated that when she saw complainant Martin get struck by the defendant and get knocked unconscious for approximately 2 minutes.
Is that number 3 or 2?
That's 4.
That's the 4th.
That's the 4th, Your Honor. The witness then stated that she saw the defendant punch complainant Martin on the left side of the face. The defendant admitted to being involved in the physical altercation with the complainant and pushing them away. The complainant 2 had a knot on the back of her head. Complainant 3 had a small swelling on the left side of her face. And complainant 4 had small swelling under her left eye and was transported to the hospital due to being unconscious.
All of this happens at TSU?
It is. It was a party, yes, Your Honor.
Mr. Martin, I'm going to find that there's probable cause to go forward with your case. I'm now barring you from going to TSU.
Yes, sir.
I'm barring you now from going to TSU. I'm also ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in this case, not to consume alcohol, illegal drugs, not to be in possession of weapons. If I find that you're a danger to my community, I will do everything in my power to take you off the street. So you understand?
Sir, I understand. May I ask what this bar?
You have the ability to hire a lawyer, Mr. Martin.
Oh, sir.
You work. I'll have you fill out an application. Deputy Miranda will give you an application. I'll see whether you qualify for an appointed lawyer. I'm going to have you sign a receipt with Victoria. Then I'll have you meet with Felicia for your bond conditions. Life is way too short to sit in a box that's 6 by 9, man. Keep my city safe. Otherwise, it's going to go sideways real quick. You understand?
Yes, sir, I understand.
Okay, come on.
Thank you. I'll go.
Right this way.
I see. Okay, Mr. Mejorado, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 9th, 2025, at approximately 3:30 a.m., officers were dispatched in response to a motor vehicle that ran off the road. The officers respond to the defendant's motor vehicle, a Dodge Ram, in a grassy area adjacent to a service road on the East Freeway. Service road in Harris County, Texas. The officer observed the defendant and walked over to the defendant walked over and advised that he was leaving the parking lot and lost control of the motor vehicle when he drove through the puddle of water. The defendant's motor vehicle left the road and got struck in the mud. The defendant stated his friends were there helping him pull the motor vehicle from the mud. The officer observed glassy eyes, slurred speech, and odors of alcoholic beverage. The defendant stated that he did not have anything to drink, and the officers relocated him to JPC to continue the investigation. SFSTs were conducted. It was a 6 out of 6 on the HGN, a 3 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The DIC was read and consented to Bragg. And the results were a .148 and a .143. It was identified by his Texas driver's license.
Okay, sir, I'm going to find that there's sufficient probable cause to go forward with the case. You look to see any prior DWIs, and if he has.
There's no prior DWIs and his license is.
Okay, Mr. Mejorado, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Likewise, if I find that you're driving without insurance, your bond will be revoked. You will go into custody. You understand?
Sir.
Do you have the ability to hire a lawyer? No. I'll have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. We'll have you fill it out. I'll have you sign a receipt with Victoria. You'll get with Fleischer for your bond conditions. Then I'll take a look at it shortly. Please. You ready? Hey, good morning. You want to do the arraignment first or which one? Okay. Come up, man, please. So she has a co-defendant. Do you guys represent the co-defendant? Do you know? No.
I believe the defendant also has a felony because he had prior thefts on it.
Really?
But she is a first-time offender. And her, and her involvement in it is not as much as the co-defendant's.
Ms. Ayala, you're charged with, you speak English, ma'am?
Yes, sir.
Okay, Ms. Ayala, you're charged with theft. Shh. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 9th, 2025, at approximately 5:43 p.m., an officer was dispatched to a Best Buy in Houston, Harris County, Texas, in regards to a theft. The call notes advised that the suspects had left the location in a red Dodge Challenger with a temporary tag that started with 74. The officer located a vehicle consistent with the description about 0.8 miles from the business. The officer was also given a description of the suspects. A traffic stop was initiated. The officer immediately recognized defendant Sauceda from previous thefts from Best Buy. Defendant Sauceda stated he took 2 items from the Best Buy without paying. The passenger, who is identified by her Texas driver's license as defendant Ayala, and defendant Sauceda entered the store and went to a cell phone station. Defendant Ayala distracted the cell phone employee while defendant Sauceda used a pair of scissors to remove 2 cell phones and exit the store. Shortly after, defendant Ayala received a text message from defendant Sauceda, and she immediately left the store without purchasing any items. The total value was $1,499.99, and the 2 items were located inside the vehicle.
Don't talk about
Ms. Ayala, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to have any contact with the co-defendant in this case. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you and barring you from going to any Best Buy in anywhere. You understand? If I find that you pick up a new case, if I find that you violate these conditions, that's it. So do you mind filing those conditions, no contact with the co-defendant, no going to any Best Buy, anywhere? And then now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for your arrest. For now, I'll have you sign a reset with Victoria. We'll have you take your seat in the jury box. So we'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay, thanks.
Judge, I have 2 bond violations. The first one is Torres Noe. His bond violation is for failing to show up to a random UA. I tried reaching out to him, Judge. Apparently, he got deported. So that kind of explains why he's.
Sure about that? How do you know?
That's what the family told my office.
Got it. Okay, I'm gonna end up revoking it then, because I can't just leave it open. I'll leave it at 2501.
Yes, Judge. And
Okay.
then we reinstate if you stop.
I mean, let's see, like, more than likely, like if it's not his fault, they just up and took him, then, you know,
Yeah, his family says he was detained by ICE and deported.
just I would reach out to the family, let them know, hey, if you're gonna get him back, do it the right way. You know, like get permission first, and then if I see that they do that, then of course, absolutely, I would reinstate it, you know? So, who's second?
And then Judge, the second one is gonna be Lambert, John.
With an L.
Yes, Judge.
Come up, Ms. Lindberg.
And Judge, I spoke with Mr. Lambert. He had a BAC of 0.03 on his interlock. I spoke with him about the incident. We talked about, let's just be honest about this and let you address it. We are asking for an admonishment because it is his first bond violation. He said he went out with friends on Friday, had some to drink. He didn't drive that night, but the following day he didn't know that he was going to be positive when he tried starting the car, and of course the ignition interlock picked on it. I did admonish him that your bond conditions are no drugs, no alcohol whatsoever. It's not only when you're driving, but throughout the pendency of the case. He understands that now. He is just asking if you would give him an opportunity to change.
You had a DWI 2 years ago. Now you've got another one. We tell you not to consume alcohol, yet it's happening anyways. So either you don't care about court orders or you have a problem.
Yes, Judge.
Have you seen how many people we put into custody?
Yes.
I'm now going to put a monitor on your ankle so I know that you're not consuming at all. I'm going to put a scram monitor that detects alcohol through your perspiration 24 hours a day, 7 days a week. I don't give a rat's behind what your next excuse is. If I find that you ever test positive for anything else again, I will lock you up. No more PR bonds. Do you understand?
Yes, Your
On
Honor.
your other ankle, I'm now going to put a GPS monitor and I'm going to give you a curfew of 9 p.m. to 6 a.m. If I find that you're out because I don't want you out in the middle of the night, likewise, you will go into custody. Do you understand? Your Honor. It is absolute no tolerance here for it. I don't care what your excuse is from now on. But no means no. Do you understand? Sir. Okay.
Thank you, Judge. May we be excused?
Yes, ma'am.
Thank you.
When parties in a terroristic threat case reside directly across the street from one another, how should courts craft no contact and distance restrictions that protect the complainant's right to quiet enjoyment of their home without effectively forcing one party to relocate?
Thank you.
Good morning, Mr. Villasana. Morning. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 7th, 2025, at approximately 7 p.m., officers were dispatched to a person found on the Electric Digital Road in Harris County, Texas. The officers spoke with the witness, who reports for HFP. The witness stated that the defendant was charged when he got to the location and was asleep in his motor vehicle. The vehicle was turned on with all doors were locked. The witness stated that he knocked on the window multiple times to see if the defendant wakes up, that the defendant did not respond to knocking, and that the witness had used a special tool to open the door and was not able to get the defendant, who seemed a little bit off. The witness stated that the defendant had told him that he had been drinking a few hours prior to driving to the gas station, and that he observed a brisk man in the middle of the console of the car. That's the defendant about it. The witness stated that the defendant had been in the hospital 3 days ago for alcohol problems, and another witness stated that multiple customers had stated that the defendant had been at the gas station, and that gas station made still witness to the cameras and saw the defendant's car had been parked there since 6:30. Witness 2 went outside to check on the defendant, and the defendant was asleep and tried to wake up the defendant by knocking on the door. He did not wake up. The motor vehicle was on. The officer observed a strong odor of an alcoholic beverage, poor balance, and disorientation. He refused SFSTs and admitted to consuming alcohol a few hours prior. A open container of Jim Beam bottle was locked in a hidden compartment of the passenger seat, and an empty can of Four Loko was located in the center console. A styrofoam cup with a lid and a cup holder with a liquid matching the color of the liquid in that Jim Beam bottle was also found. The DIC was read and the defendant refused breath. The blood warrant was signed and executed and was identified by his Texas driver's license.
Are you telling me that he had alcohol in the car while driving?
Yes, Your Honor.
Mr. Villasana, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you not to drive any vehicle whatsoever for any reason. Do you understand?
Yes, sir.
If I find that you do, I can have a contempt hearing. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you to obtain a portable device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. If you have a problem with alcohol or illegal substances, you better address it, because if you don't, and it becomes a problem, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
I am sending notice to DPS and I'm placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an interlock on it. I'm sending notice now to DPS in Austin so that every police officer in the state knows that if you're caught driving a vehicle and that vehicle doesn't have an interlock, they will take you to jail. Because I'm ordering you not to drive now, that's why I'm giving you a portable device. But do not drive. Do you understand? You get no more warnings. If I find that you do, I'm going to lose it. Do you have the ability to hire lawyers, sir?
Sure.
Okay, we will give you time to go hire a lawyer. I'm going to have you swear to us that you're not going to drive. I will get you to Victoria where we will have you sign a release it. You will get with Fleischer if your bond conditions. After that, you're free to go. Be careful, Mr. Villasana. Okay. You are Alejandro Castillo.
Castillo? Yes.
Mr. Castillo, you're charged with failure to stop and give information. Essentially leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On March 6th, 2025, at 9 a.m. Officers were dispatched to a location in Texas. Upon arrival, the officer met the complainant. The complainant stated that she was sitting at a red light and she was struck by the defendant, and then the defendant left the scene. The complainant was able to get the vehicle's license plate. The complainant followed the defendant through a residential neighborhood where the defendant lost control of the vehicle and crashed into a house about a mile from the original crash. The complainant committed damage to the amount of $2,500. It is not copyrighted.
That's what I was gonna ask you. Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, and immigration finds you in the jail because they sweep it every single day, every couple hours. If they find you in there, they will place an immigration detainer on you and you will be stuck like Chuck in there until this case is over with. And then you will be shipped off to immigration where you will sit. It takes 9 months just to get a 911 tape here. So you will sit for that time, then shipped off to immigration. I don't know what your status is, but if you're not here with permission, you better live with a halo over your head and not violate any conditions that I put on you now. I'm ordering you not to drive. You do not have a Texas driver license. You do not have liability insurance. You are not to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that a baby needs to go to the hospital. If you don't have a Texas driver license and liability insurance and approval from us, you are not allowed to drive. If I find that you break this condition, your bond goes bye-bye. You have the ability to hire a lawyer.
No.
I can have you fill out an application and I will take a look to see whether you qualify for an appointed lawyer. I need to know everything about you. We are filing conditions that you're not to drive. Do not leave until you sign our bond conditions. Deputy Miranda is now going to give you an application for an appointed lawyer. I will have you sign a receipt with Victoria and then we'll have you take a seat in the jury box.
Was that a financial affidavit?
Yeah. Good morning, Mr. Reyes.
Good morning, Your Honor. Always a pleasure seeing you today. Same here, sir. Looking sharp, Judge.
You're Miss Grab?
Yes, good morning.
Good morning, ma'am. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On March 9th, 2025, at approximately 1:08 a.m., an officer observed a vehicle on the 5,000 block of West Road, Harris County, Texas, speeding going 58 miles per hour in a 40-mile-per-hour zone. This was confirmed by Dr. Rear. The officer followed the vehicle and observed the vehicle to fail to maintain a single lane several times. A traffic stop was initiated. The vehicle did not initially stop. The officer initiated sirens, at which point the defendant's vehicle increased in speed and continued to fail to maintain a single lane and failed to signal lane changes to get around another vehicle as the officer was in pursuit. The vehicle finally came to a stop. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have red, bloodshot eyes, thick, slurred speech, and the strong odor of an alcoholic beverage upon her breath. The defendant admitted to coming from a wine bar and said she had 2 glasses of wine. As FSTs were conducted, 6 out of 6 clues observed on the HGN, 5 out of 8 clues observed on the walk and turn, 3 out of 4 clues observed on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were 0.100 and 0.101.
You said she was going 50 speeding or 40?
58 miles per hour and 40 miles per hour.
Got it. Okay. All right. Ms. Grab, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
You have a lawyer. He will take care of you. Because you do, I will waive your appearance. Just stay in touch with him and he'll tell you if and when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. Oh, does she have a license?
Yes.
No prior DWIs?
No prior DWIs.
Okay, we'll have you sign a reset, Victoria. You're not allowed to drive unless you have valid liability insurance as well. If you don't have car insurance, do not drive. That is a condition of your bond as well. Do you understand?
Yes, sir.
Okay, I'll have you sign a reset, Victoria. You'll get with police of your bond conditions, then you're free to go.
Thank you.
Take care.
John C. Joseph, It's my understanding that you want to talk to him and see why he didn't appear in court on his last court date.
So this is basically an arraignment.
Yes, sir. I understand that we were gonna do it as an arraignment.
He's been AWOL. It's now 400 days, 350 days old. Mr. Joseph, you're charged with two cases. You're charged with burglary of a motor vehicle. You're charged with unlawful carrying of a weapon. Your cases are now 352 days old. It's time to decide what we're going to do. Do you have offers on these cases?
No, sir, we're still waiting for the security video.
We do have an offer, but yes, we are waiting on the security
I
video.
need you to get on it
Absolutely.
like yesterday.
Yes.
I'm ready to set this case for trial. Way too much trauma, and I'm not gonna just.
Yes.
Mr. Joseph, I'm now going to put an ankle monitor so I know where you are at all times. If I find that you have one on now, you take off on me again, I'm gonna make your bonds extremely high. Do you understand? I will
Yes,
give
sir.
you a big flight risk and the bonds will go very high. At some point, someone's gonna stop ponying up all this money. You're just giving free money to bonding companies every time you take off, man. That's all you do. On your burglary case, you're not to have any contact with the complaining witness in these cases. You're not to be in possession of any weapons.
Did you say you already have something going on?
Yeah.
From, is it from Harrisburg?
Mm-hmm. I turned myself in the other day and they ain't nothing better.
Don't say anything. I don't want you to say something. Perhaps the magistrate put it on.
I don't see any magistrate conditions, but
He's got two cases. Look at the other one, please.
here at them, we're supervising an ankle monitor order. We had one on him back in April of last year, but we haven't been supervising it since June due to the warrant.
All right, I want to go back to the original bond conditions that had a curfew with the monitor on now. No alcohol, no dope. What do you do with yourself these days, Mr. Johnson? Mr. Johnson?
I just started for a job. No, sir. I just started for one, filling the application.
I'm going to bring you back in 2 weeks. I want to see what you have done to get a job. Did you graduate from high school?
No, sir.
That's what we're going to also work on as well. I want to see what you've done to start working on your GED as well. I'm giving you 2 weeks. If you've not done anything, it's not going to go well for you. Do you understand?
Yes, sir.
Okay. All right, Mr. D, I'll give you a couple weeks, but I want him back in 2 weeks here to see what we've done to either get a job or get his GED.
Yes, sir.
Okay, if nothing, then it's not going to go well.
Yes, sir.
All right. Hi, Vic. What's up? What's new, man? Good to see you.
Good to see you.
Happy Friday.
Happy Friday.
You mean
PSI on it rather than fully upstairs, so it made my Friday a lot better.
scary though?
It is.
No, let me tell you, I did a PSI once where I was basically going to get probation and then got smacked with 25. And
it is enhancement. I'm on. And it's working and it's got a lot of support. And it's really a silly case. It's a silly case. It's evading arrest, but it's.
I trust you.
Yeah.
You know, you're the best, but PSI, I just.
There's always risk there, but the state was at 15, so.
Yeah.
Melgar, Daniel Melgar, this is my PTI packet. He had to do it yesterday.
Okay.
To Abigail and.
Well, that's to Judge Geis, right?
Yes.
Okay.
I think
everything submitted?
Everything submitted, all the discoveries turned over. The 0.16 was just a little bit above the. I think you were.
Why? So were you denied?
We were told to submit a mitigation. Yeah.
Okay, so it wasn't a denial and then you appeal,
Correct.
right? They just submitted a mitigation.
We
package.
submitted a mitigation packet.
All right, we'll give you a week.
Sounds good, Judge.
Hopefully we can have a decision within a week.
I hope
If no decision is made, I will waive the appearance. We'll give them a little bit more time.
Okay.
If it's approved, your guy's got to be here so we can send him for a T-Rest. Okay?
Sounds good.
Yes.
And then we'll just come back. Hopefully they got it within a week to make the decision or not.
Sir.
Yeah.
It's good.
Okay.
Good. Thank you. Nice to meet you.
Good luck, Vic.
Thank you, sir.
Are you on probation or parole at this time?
No.
You were on parole in 22. Is that over now?
Yeah.
Okay. So I don't show any holds on you now. I don't see any. Do you guys? Yeah, we don't see any holds. But if you continue with what this has happened and this keeps happening, the sentences just get longer, longer, longer. All of it control, Mr. Kaufman. You're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 15 days in jail with credit for the 7 days that you've done. You need to understand that this is going to go on your record. From now on, you're facing a minimum of 90 days in jail. Do you understand? So Lori, the trespass is being dismissed.
Are y'all dismissing the trespass?
Believe so, yes, Your Honor.
The spot we were, we will assist the trespass.
There is a trespass, right?
Here's a trespass. Was the plea paperwork for the trespass?
So they're going to dismiss the other case that you got. But like I said, you're still facing a minimum of 90 days in the future. So you pick up another case, it's just going to be a long time. You understand? Yeah.
Yes.
Yeah. But if you want something, if you need something, we have services for you. If you need a place to sleep, you need food to eat, we got you. All you got to do is ask. But this, you're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal, Mr. Kaufman. So once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do? How do you plead to the offense, or guilty or not guilty? I'm going to find you guilty. I'll send you to it. Good luck, sir. Thanks a lot.
Judge, can I start with Alator Aristelsi for a bond violation? She tested positive on 3/4 on March 4th for cocaine, Judge.
Can you bring her up, please?
And Judge, this is her first bond violation. If you'd be willing to give.
Ordered you not to use, you're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go. Marijuana, alcohol. No, you're testing positive for cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you second on that, Judge?
$5,001.
And Judge, I have two more. I have Enrique Flores.
Enrique Flores, come up.
And Judge, on this one, he was in lockout since March 6th. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a first bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, it's the second. The first one was for the same thing.
Take your time. No rush. Deputy, you going? I need your help. No. Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. Now goes with you. No?
What did you set his bond at, Judge? 5,000?
What's the last name again?
Flores, Judge?
Thank you. 5,002.
5,000.
Yeah.
All right, Judge, and I have one more, and it's Gomez.
Okay. Okay, Gomez, come up.
So Judge, he did take a drug test today because he had failed to report for a drug test on February 21st, and he tested positive for marijuana.
You see how many people we've taken into custody? I've ordered you not to use, and you're now testing positive. If I find that you ever test positive again, I will put you in jail. Do you understand? When I say don't use, I absolutely mean it. You will get tested in 50 days. If I find that you continue to use, into jail you will go. Do you understand? Yes, Your Honor. Yeah. Absolutely no tolerance here for it. And the next time you miss an appointment, likewise, you will go to jail. Yes, Your Honor.
Thank you, Judge.
Yeah, reset 50 days must appear.
Okay, thank you, Judge.
All right, so Mr. McGee, you've worked out an incredible, well, not you, your lawyer has worked out an incredible deal. You're charged with five it's five open cases, right? Shh. You're charged with evading arrest, failure to identify oneself, evading arrest, theft, burglary of a motor vehicle, and I think that's it, right?
Right.
As part of the agreement, you're going to plead guilty to the burglary of a motor vehicle and the evading arrest. You need to understand that both of these cases are enhanceable cases, meaning if you pick up another one of these cases, it's very possible they charge you with a felony offense. Now, in the burglary case, it may be 2 or 3. I think it's a third, it's a felony. But on the evading case, you pick up a second one, you're looking at a felony charge in years instead of days. You understand? So I don't know who you're hanging out with. I don't know what you got going on in your life, but you got to surround yourself with better people, because you start the wrong people, they're going to bring you down. Don't become another statistic. We have enough Black and brown people in custody now. Don't become a statistic. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you plead guilty to these cases. You can't do anything else. It goes on your record. It'll be there forever. How do you plead to both cases guilty? Mr. McGee, if you need anything, just come back, talk to me. I'll get you whatever you need. If you want a place to stay, food, cell phone, tablet, we can work just about anything to get you what you need. It's never a problem. But would you get out there, you get on the street, you got to be careful, man. You get for one life. You don't get another one. There's no redos. Good luck, man. It's 30 days. I'm sorry, 30 days in jail, credit for the 29 and 31.
Okay.
It's Tyron, whatever you'd like.
So we can, maybe we
I don't know
can.
what a bond is because it's kind of. Oh, gosh.
And maybe we can review PC. I think we're in agreement with the trespass. There was no trespass for the.
I'm always happy to hear PC. Let's do it.
Yeah.
Jay, you want to do it or no?
Let's do it. Okay.
All right.
What's the contract number? 255 4294.
It's on document.
Oh, it is?
Yeah.
Sorry. Okay.
On March 4th, 2025, at approximately 10:30 a.m., officers were conducting an investigation for an evading case at Oyo Hotel. The officer made contact with the manager of the hotel, who showed surveillance video that showed a male who had been given several trespass warnings and stated he refused to leave and comes back all the time. The suspect was a black male with a jean jacket and dreads. There is also a posted no trespassing affidavit on the front of the hotel. The officer spotted the male and attempted to make contact with him. The officer approached the defendant and the defendant began walking away, and the officer advised him to stop. The officer placed his hand on the defendant's arm and the defendant began running down the stairs carrying his bicycle. While running, the defendant used his bicycle as a barrier and shoved it towards the officer, hitting his left knee. The defendant continued to run around the motel, and he grabbed his bicycle, which he left on the left side of the building, and the officer was able to take the defendant into custody after a taser was used. The defendant was identified by his Georgia ID card. The defendant has an open probation violation warrant out of Louisiana for a weapons charge.
So he's at a hotel.
Yeah,
Was he, you're saying he's not allowed to be there?
correct.
Are you saying he was?
There's no trespass warrant on file with his name on it. I believe there's a homeless encampment near this hotel, off Highway 6. And so a lot of the homeless people go back and forth. Mr. McGee is homeless. I don't know. It's not clear whether Mr. McGee is the person that they're referring to. I know he's a black male with dreads, but he's never received a trespass affidavit. And there's no information of that.
You said that there was one.
It says in the DIMS that the complainant pointed out the defendant on surveillance video and said, I have told him several times, I've given him several trespass warnings and he refuses to leave and he comes back all the time. And then also it is stated in the DIMS that there's a trespass affidavit posted on the front of the hotel.
Okay, but that doesn't mean anything. That just means like no trespassing.
And usually with
It's like,
trespass affidavits, he was there visiting someone that stays there. So in all of the loitering with convenience stores and things of that nature, that applies to people that are there without any kind of, if you're not buying anything, visiting anyone. So he was visiting one of the people that was staying there. That's why he had his bicycle. The police, basically just grabbed him and he was coming down the stairs. So I don't think we have a valid trespassing case because there's no affidavit with his name on it. And if he was there legally visiting someone at the
Is a
hotel.
verbal trespass warning sufficient?
I would disagree, Your Honor, especially because and I guess we would need to see what their trespass affidavit says, because usually the ones at the convenience stores, I've dealt with this a lot. It excludes people that are there legally.
I mean, I get that the penal code doesn't say that it has to be in writing though.
Mhm.
You know, I mean, it could say, hey, I don't want you here. Don't come here anymore.
Mhm.
So
But then if we take that blanketly, that there's a trespass affidavit, then that means.
but then anybody could say,
That's
it.
correct.
I get it. I get it.
Go in and visit my aunt, and she was staying at that hotel, so it can't be that restricted. If he was there with his bicycle, he wasn't just out in the front visiting someone, he was up inside of the hotel with his bicycle coming down, he was there visiting someone. So I don't think that there's any information or evidence that says that.
So the state would concede that a general trespass affidavit would not be enough. So it would be due to the verbal trespass warnings that were given to him several times by the manager and him refusing to leave the location.
So where do we go from here? Like, how are we gonna?
My goal is, Judge, or my hope is that the state, in looking at this and knowing that he has a case out of New Orleans, which he's on parole, I'm hoping that they will resolve these issues. I have spoken with his parole officer, and bond or not, he is going to have to sit in jail another 14 days to be extradited. But because he's on parole, I cannot plead to anything because I want him to get to New Orleans and have the ability to potentially get terminated.
They're coming, we'll see, right?
They are,
But it's Louisiana, so they should be here.
it'll be pretty fast.
I mean,
The larger part of it, it's not Louisiana jail, it's not Thursday Parish jail, this is a parole violation. I think what council's saying is that for whatever they contend for the parole violation, they're gonna have to have it before the board. Well, obviously, if he takes a conviction, that's gonna affect his eligibility versus a dismissal.
But there was already a warrant regardless. Something happened regardless of perhaps he absconded or.
Because he had been here homeless off the grid, so he was being a resident and things like that. And so that's why. But of course, we've been here.
Right. The only problem, Ms. Sparks, is that the 14 days or any time it's told.
As long as this is going on.
Well, because he's not made, you know.
Yeah.
I think one of them.
I'm showing both their.
Yeah, no,
He's not made bond on either.
we were told it made no sense to me.
If I may, last Friday, we revoked the bond in the local case to keep Louisiana from coming to get him.
Oh,
that's this one?
I don't remember
Yes.
that. I didn't remember that. I thought it was someone else that we.
Yeah.
Okay. So.
That way you would have to go back and forth, deal with the same.
You're right. You're right. She's right. Because the problem is that if they come and get him, he goes over there, then a hold gets placed on the exact same situation. So
I trust Mays and his staff.
Guys.
Stand down.
whatever you want to do, if you want to set it maybe just a couple days to look further to see if there is anything, if you could probably perhaps somehow get that he's actually visiting someone.
Yes, Your Honor.
No.
Okay. Yes, Your Honor. I'll stand down.
You know, Mr. Flores, I really don't know what it's going to take to get your attention that we're not going to stand for anyone endangering our public. Really. I mean, you've had in the last 3 years, 3 very serious cases, and now you're picking up a DWI. All of them are dangerous cases. What's it going to take? A 25-year sentence? Is that what it's going to take to get you to realize, you know, all the stuff here is things that if you just think, they don't have to happen. All the time, all the money, all the just that you spend coming here can all be avoided by not using. You know what I mean? That's all it takes. From now on, what we're doing today, you're now facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? There are more proverbial slaps on the wrist. What you're pleading to now is a DWI. This DWI will go on your record. It will be there for the rest of your life. You can never take it off. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this case, like I said, it'll go on your record. You can never take it off. Do you understand? You know, the other thing is this, is that your lawyer is asking to waive all the fines and fees. If you ever pick up another DWI, it is a $6,000 surcharge that you will be required to pay. And if you don't pay it, you sit 1 day for every $100 you owe. If you want to get lit, 52 beers, 32 shots of tequila, take a freaking Uber. $40 wherever you want to go in this damn city. Don't kill anyone. How do you plead to the DWI? Guilty or not guilty? I'm going to find you guilty and I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 180 days. Don't get into a car. Driving on a suspended license case is just like a DWI. You pick one up, you're going to be right back in here, and it's just not going to go well for you. You understand? Yes. All right, good luck.
Thank you, Judge.
I have, Mr. Escamilla and, Ms. Victoria says we need to approach you on the reset because you sent him for a drug test, Judge.
Positive for what?
THC, Judge.
No more. You are not allowed to use. It is a condition of your bond. I will give you up to 50 days, and I'm going to test you again. If I find that you continue to use, I will put you in jail. No more PR bonds for you.
Yes, sir.
You take off on me again, it's really not going to go well for you. Do you understand?
Yes, sir.
Okay, I put a GPS monitor on him and I've given him a curfew because he's taken off on us many, many times. His case is 1,000 days old. So I'll give you a reset, but I think that we were waiting on, is discovery complete on the assault case?
It says the only outstanding thing is, photo from the complainant.
Okay, if you can please get that.
Judge, just for the record, I was just appointed to them. Okay.
No, I'll give you time.
Thank you.
Sure. But I'm gonna test you like crazy. Just get ready. It's on your ball.
Yes, sir. Understand.
It's your responsibility to stay in touch with her. If she tells me she can't get a hold of you because you're ducking and dodging, likewise.
Yes, sir.
Jail you will go.
Understand.
All right?
And,
Okay, Ms. Tichy.
Yes, Judge, we've had a long talk this morning.
Good.
And he was really good about communicating earlier.
And
Okay.
for my
Yes.
curfew, I work a night shift. I work 5 p.m. to 5 a.m. So
Judge, can it change to allow him to work?
I want proof. Show me proof. You're not gonna take your word
All
for it.
right, but she'll send it to me and by Monday I'll bring it in and we'll adjust. Does he need to be here if you're gonna adjust the curfew or can I just come show you?
Bring me legitimate proof and we can
And then we'll talk.
And then, but remember, the GPS monitor tells me exactly where you go
Yes, sir.
at all times. So if you deviate,
Just worry about it. Yes, sir.
all right, okay.
I'll get the proof, Judge. Thank you so much.
Yes, ma'am.
All right, have a seat.
Good morning, Mr. Goff. The reason that we took you into custody now is because you were on deferred for an aggravated assault of a family member. It looks like that's in warrant status now and no bond, actually. With us, you've picked up a possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 5th, 2025, at approximately 11:15 p.m., an officer observed a vehicle parked in a handicapped parking space with no displayed license plate or placard and then leave the parking lot. The vehicle had expired registration as of July 2024. A traffic stop was initiated. The defendant was the driver and he was ID'd by his Texas ID card. The officer observed the strong odor of marijuana emitting from the vehicle and the defendant admitted to being in possession of several small plastic bags of marijuana under the driver's seat. A probable cause search was conducted and 4 bags were located under the driver's seat, 0.154 ounces.
All right, Mr. So he doesn't have a license, correct?
His driver's license is eligible, Your Honor.
Mr. Goff, I'm going to find that there's sufficient probable cause to go forward with the case. I'm not putting any conditions on your bond now. Just behave. That's all I'm asking you to do. You know, you're on felony probation. You're supposed to have a halo over your head, you know? When you don't, bad things happen, as you now see. Can you go ahead and appoint him a lawyer now? So I'm going to appoint you a lawyer so that you can speak to someone. We'll take you into custody now. You'll probably hit felony court Monday, and then we'll just give you a reset of like a week or two to figure out what happens. Okay? All right, man. Good luck.
In Mr. Torres's DWI second plea hearing, the court conditions waiver of approximately $6,500 in fines/fees on the defendant demonstrating proactive rehabilitation within 2 weeks, raising a nuanced legal question. Does linking financial leniency to future behavioral proof create an impermissible ex post facto incentive or a legitimate rehabilitative tool? The judge's directive, "Don't write me a letter. I want something really proactive that shows me it's not going to happen again, establishes a behavioral evidentiary standard for leniency, shifting the burden to the defendant to prospectively prove rehabilitation rather than the state proving risk. This exchange illustrates how misdemeanor courts increasingly function as behavioral modification forums, using financial leverage, license restrictions, and conditional waivers to incentivize long-term compliance, even where statutory mandates limit sentencing flexibility.